Madam, you posted to 30th June, madam.
Not matter. This matter is matter.
It is one of a pay of the petitioner and the read petition is pending before this honorable court.
This matter regard to transfer my lord. Can take it tomorrow. This matter regard to transfer. Can take it tomorrow. This is a transfer matter, madam.
When it was, you were
Transfer just next week, 31st 8 mile.
31/8.
Mile.
But what were you doing?
I'll take it tomorrow, mile.
Okay.
24 matter.
24. Up to
24
Morning is some matter, my lord. Petitioner was working as a lecturer.
Don't say the facts. What's the urgency?
Has been terminated after 18 years.
When?
In the month of May.
In the month of May. Up to 2 months.
Urgency of the transfer matter, second Monday matter.
Transfer matter.
I have been suspended. Why usually I have posted claim distance for lady teacher.
When order was made?
Order passed in 27 July. That's August, madam.
August?
That happened Monday, madam.
One second.
Yeah.
Huh?
Service matter, the petitioner is
Which year?
2025.
25?
Yes, sir.
2 weeks.
We pattern to mention, my lord.
Admission or after notice?
After notice.
After notice? 3 weeks.
Pattern to mention, my lord, is the after notice matter, my lord. Petitioner claiming MA scale, MA in Sanskrit, my lord. Since 2024, my lord, 7/10/2024 notice has been issued, but no counter has been filed. Petitioner is continuing without any remuneration, my lord.
Should may pardon to mention, the petition has been retired from since 2016. It has been 10 years. She has not been paid or her gratuity has been given to. Thank you. Much obliged.
Yes.
Lordship, I am mentioning through BC. Am I audible, your Lordship?
Your half face is visible also. Full voice is audible. Half face is visible. Anyway, no problem.
Lordship, I am mentioning for a FO bearing FO number 161 of 2024. In that case, all the appellants have retired, your Lordship.
You question right?
Lordship has fixed Thursday for the FO. Kindly, this may be listed on 11th.
11th?
Yes.
First day. Well,
Obliged.
One matter, recovery matter. Retired person, recovery has been made.
recovery. When it started?
Recovery has just already collected by from my GCR amount, my lord.
You want to get back that money now?
I will.
You will wait for tea. So,
Are getting a provisional pension. My lord.
he's a widow.
Okay.
Next week. Yes.
Item 1.
Yes.
Pension matter. Similar to the block land employee. That means
the division bench is the exception of the matter. So, you know, all this matter calling in 3rd week of September.
3rd week of September?
Yes.
AGM is to request accept notice for the respondents. All the OPs, you only.
Yes, sir.
Any private OP?
No, OP number 3 private.
3 and 5.
3, only 3.
Only 3.
Yes, ma'am.
1 and 2, Mr. Lenka.
This one.
1 and 2, Lenka.
1 and 3 and 4. 1, 2 and 4.
1, 2 and 4. Okay. Number 4 is to private fund.
Item 2.
Item 2 also same.
Along with WP numbers?
WC number.
We have.
11539 by 2020.
Give that.
1, 2, 3, 19. Item number 2 also same.
Same.
Private opposite party, no private opposite party, only government. 3 also same.
3 also same.
No private opposite party. 19 also same. 19.
19.
Item 4.
Item 4, please, your lordship. The grant of pension, my lord, similar to item 3.
Item number?
Similar to item number 1 to 3.
4. All along.
Item 5.
Item 5 also similar to 1, 2, 3, 4, 1. Private party.
Any private party?
Open note 3, madam.
Okay, nice. Okay.
Item 6, jealous. The petitioner is filing challenging the order of transfer that for 2005 at annexure 1, my lord.
4/2/2005.
My lord, 2005. Serial number is 2. Serial number is in 2.
But transfer matters, if you challenge it after so much delay, what can be done?
Sir,
When did you?
on my request, they have allowed me to work, assuring me not to transfer. But in the meantime, I have been relieved by the order annexure 3 at page 30.
And it's a 3 page 13,
My lord.
18/7.
18/7/2025, I have been relieved, my lord. So, but my less than 2 years is my service, less than 2 years, and I have not completed 3 years in the present station. Apart from this, I am suffered with different ailments. The session I have also annexed at 5 and 6.
What are the ailments? Generally, at the age of retirement, all will have ailments, no?
In similar cases, your lordship has also Minati Brahma.
But 1880 is over.
My lord.
1880 is over. And now you are here.
My
Yeah,
lord,
third of September.
only 1 and 9 months is left for my superannuation, my lord. That I have also mentioned.
You ask them to continue. Let us see.
Your lordship has this identical matter.
We have interim order also we have granted.
No, your lordship has disposed of my.
Disposed of direction to consider.
Yes, consider, and if he has been relieved, she should.
Have you given any representation?
Yes, my lord. Annexure. That is annexure 4, my lord.
Annexure 4.
4, my lord.
Dated
That after relief, that is 22/7/2025.
Take up. You are a teacher in a government school.
No, sir, BO, Block Education Officer.
A teacher in a government school.
Teacher, no, sir, BO, Block Education Officer.
Block education officer.
Block Education Officer in Bhandaripukri, Bhadrak.
Not teacher.
Not teacher. BO, Block Education Officer.
Teachers I would have given reprieve considering difficulty, etc. For BU, what is the difficulty?
This same, my lord. Teacher and BO, I am also working as a teacher prior to this.
Prior to this, we were all adamant you.
Sir,
That makes no sense.
sir, only 1 and 9 months is left for my.
Only 9 months is a long period.
Apart from this, I have suffered with.
What is the retention period? Retention period of one in a particular place. What do you call it, Mr. Swain? What do you call it? Retention period. Transfer guidelines.
For teachers, 6 years.
For a BU also.
No.
Teachers, it is 6 years. Therefore, I granted interim order. For teachers, for your cadre.
Similar for all, my lord. 6 years.
Show that. But you have to show, brother. I'll pass it over. You bring the transfer guidelines and show them. Is it 6 years for them also?
So
May not be.
it is not specified there that for teachers or BO.
A block education officer is knocking at the doors of the court, grieving against non-consideration of his representation dated 22/7/2025, where he has at an court wherein he has sought for his retention in the same place on the ground that he has only a short stint of service of less than 2 years for superannuation, and that he is also suffering from certain ailments natural to the declining age. First up. He further contends that, argues that, learned counsel for the petitioner argues that when representation of the kind is made, the commissioner cum secretary to government ought to have taken a call on that, and that there is no hope that such a call would be taken in the near future. And before the transfer order dated 4/2/2025 is put in fruition, FRUITION, fruition. First up, in all fairness, he finished to the notice of the court that though the transfer order was made on 4/2/2025, his client has been relieved only on
18/7/2020.
sit down. 18/7/2025, and therefore he should be permitted to continue in the same place till a call is taken on his representation. First up, he also quotes the constitutional mandate enacted in Article 350, as interpreted by various high courts. First up, next paragraph. Learned AGA, on request accepting notice for the official OPs, opposes the petition, contending that it is the bounden duty of all government servants to go and report for duty at places wherever they are posted or transferred, and that there is no immunity from transfer in the light of Varadhara versus State of Karnataka. Apex position in Varadhara versus State of Karnataka. First up, having so contended, now in all fairness he agrees that he would instruct his clients, official clients, to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law and in a time-bound way, should all grounds be kept open. First up, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, this petition is disposed of, directing the commissioner, OP commissioner, comes secretary to government to examine petitioner's grievance in the grievance couched in the subject representation and inform result of such consideration to the petitioner in a time bound petitioner within a reasonable time. First of all, till that happens, petitioner to be continued in the post in which he was continuing before the issuance of the impugned transfer order.
Recording in progress.
Kept off. First. Next paragraph. Petitioner shall not be made to rush back to the court seeking implementation of this order by instituting one more set of proceedings. And in that eventuality, and in the contra eventuality, heavy costs may be levied on the official concerned, payable from his pocket. Okay. Web copy to be acted upon.
Complex.
Item 7. And in this case, my lord, the present petitioner pays for a direction to the opposite parties to grant headmaster scale of pay in view of the judgment passed by the coordinating bench.
Where is your representation?
Under Annexure 1, my lord.
Dated?
Dated, my lord. 21/11/2024, my lord.
21/11. But 14/8 it bears the seal, na? You have given it only on 14/8, or this is the seal of the court? Seal of the court.
21/11/2024, my lord.
Right. Is a teacher.
My lord, retired headmaster.
Petitioner who retired as the headmaster of a government school is pleading against non-consideration of the representation dated 21/11/2024, a copy whereof awaits at Annexure 1, wherein he has sought for extension of a particular pay scale with effect from 10/11/1991 till his date of superannuation in the light of a coordinate bench decision in which is that
Annex 5 page 20.
This you just use that. Okay. In
WPC OAC 326.
WPC OAC 3264 of 2017 between Viraja Prasanna Satapati versus
My Lord Judge, Ramchandra Sahu versus State of Odisha.
Ramachandra Sahu versus State of Odisha,
Yes, ma'am.
disposed of on
17/8.
17/8/2022, my Lord.
17/8/2022.
My
We
Lord.
have a very different format of
Yes.
judgments. Personal. Next paragraph. Learned counsel for the petitioner also notifies the court that this matter is affirmed by the Supreme Court.
Well, I do not know.
Well, you have written in your representation, na?
See, in other cases,
Huh?
the state government went to the Supreme Court and the SLP already been dismissed.
Stingy.
SLP number.
So notifies to the court that the said judgment was carried forward to the apex court of the country and the SLP number
SLP number 16215 of 1991. Man, earlier the same matter already been decided by this honorable court, and the state government went to the Supreme Court, Miller.
what I am asking, na?
But in the present, Ramchandra Sahu, whether the
Annex one. Annex 1. SLP C number 19665
my lord,
of 2023 disposed of on 31/7/2023. First up, he submits that if a direction is issued for consideration of the subject representation in accordance with law and in the light of the aforesaid decision, kindly be seated. His client would be satisfied. Next paragraph. Learned, just consider that they agree for consideration.
my lord, one submission more, my lord. After passing this judgment, the concerned school and mass education secretary, Annexure 4, my lord, directed the secondary education Odisha Bhubaneswar and all DOs for verification of documents and reverted headmaster, similar situated persons. Those Annexure 4, my lord.
Next,
4. Basing on that, dead my lord 23/9/2024, my lord.
23rd.
9/2024, my lord.
Next.
Thereafter, the concerned DO submitted the present petitioner name
Recommended for
recommended 27/3/2025, my lord. And the petitioner name is serial number 1, my lord.
Annexure 6.
Annexure 6.
6. In the light of that, it should
My
happen.
lord.
Kindly be seated. Learned AGA, Mr. Lenka, request accepting notice for the OPs. Very fairly submits that he would instruct who has to take the decision. OP number? Sit down and answer. Not primary school.
Copy number 1, commission comes second.
OP number 1, to look into the grievance of the petitioner as has been aired in the light of the representation and also the recommendations made by the officials of the department favoring the employees like the petitioner, in a time-bound way and in accordance with law, keeping in view the decision cited. First up, with this proposal, petitioner's counsel is agreeable. First up, next paragraph. In the above circumstances, the petition is disposed of fixing a period of 8 weeks for taking the decision in the matter, time to inform the decision taken to the petitioner in writing. First, all contentions are kept open. Next one, it is open to the answering OP to solicit any information or documents from the side of the petitioner as may be required for due consideration of the subject representation. However, subject to the writer that in that case, delay shall not be proved. First all. At this stage, no costs. Okay.
Item 8.
Wait, may I please, Your Lordship?
Yes.
Your Lordship, in this writ petition, the petitioner is a demonstrator, Your Lordship, and is praying for the grant of RACP benefit, Your Lordship.
We
His
have
prayer-
issued similar matters we are examining, na?
Yes, Your Lordship.
That notice. The EGA is requested to accept notice for the OPs. Call this matter along with WP number
22638,
of 25.
obliged, Your Lordship.
Okay. Yes.
Item 9.
Item 9, Malot.
That together we can take up those.
Yes, Malot.
We'll pick some.
Both the matters have been taken up together, Malot.
Correct.
You're
Malot,
filing counter in the main matter.
Yes. You
they
file
are filing
You file,
counter.
it's ready, we have it here. If Lordship wants, we can e-file it, or in court also we can file.
in the file in the court hall because in the registry because they have to examine whether compliances are.
Scanning and all that.
Scanning.
Sir, copy on the learned.
Yes, Malot. Copy has been
Already served.
Malot. I'm just praying for stay of the blacklisting, Malot. On the face of it, Malot.
What happens now if it is not?
Malot, if it is not stayed, I have ongoing projects all across sale, Malot. Malot in Durgapur, Vishakhapatnam. Malot, if it is not stayed, I will
So
suffer.
any action is being taken pursuant to that?
Malot, new tender has been floated also, Malot. That is why, Malot, there was a
When it
panic
is-
order.
When it is floated?
Malot, 27th of August.
27th of August.
Yes. Malot,
I serious objection that this is corporate fraud.
no, this is not.
40 crores.
Let me explain, Malot. But let me explain. Before
I'll oppose this entry.
of course, he'll oppose Malot.
Guarantee being.
What had happened, Malot? I'll just
Bank
explain.
guarantee given.
Yes.
I'll just explain to your lordship.
This would wreak havoc.
This will not wreak havoc, my lords. I have been duped myself, so I'll explain how it has been done.
Are you
My lords,
ready to give a fresh bank guarantee?
exactly, my lords. That's what we have already offered. That I'll give a fresh back guarantee, my lords.
But the one which you had given is fraudulent.
My lords, yes. I'll explain how. My lords, I fell short. We have works, 5 or 6 works, my lords, all across sale, my lords, in India, my lords. Now, my lords, I fell short of a bank guarantee, and it's a normal commercial practice, my lords. There are agencies who, my lords, here with the bank,
Outsource the bank guarantee.
outsource the bank guarantee, and my lords, from the site of PSB, that is Punjab and Sindh Bank, that they created a fraudulent, my lords, website. From the site of PSB, a bank guarantee was, there was a communication to us and other things. We are issuing a bank guarantee. Now, my lords, what happens? My employee goes to verify whether this bank guarantee has been actually, we get the bank guarantee and we have given it in our tender, my lords. That is, my lords. Then we have paid 2.5 crores for getting this bank guarantee, which is their fees, my lords. The agency which gets us the bank guarantee. Yes, my lords. My employee goes to the bank because, my lords, what happens? We are aware for 60 years we are working with SAIL that once bank guarantee is given, SAIL asks for a confirmation from the bank from which it is issued. And sometimes what happens? This bank delays it, my lords, and work orders are not issued because of the delay in the banking procedure. So our employee goes to the bank to find out whether this bank guarantee, whether a confirmation has come from SAIL or not. If it has come, please reply immediately, yes, we have issued this bank guarantee. Then he informs us that no such bank guarantee has been issued to you all. Immediately we write to the SAIL, my lords, which is there on record and everything, my lords, that I have, there is a defect in this bank guarantee. Please allow me to replace the same with a genuine bank guarantee.
Correct.
No, it is there on record. I'll show it to your lordship.
Read that.
Yes, my lords. Yes, my lords. That is at running page 244. Running page Annexure 6.
I will hear you all.
Yes.
My lords. Annexure 6, my lords. Annexure 6.
Read that sentence.
Yes, well. We regret to inform you that due to some confusion, the subject bank guarantee submitted against the contract is having mistakes, for which we request you kindly consider to return the said bank guarantee at the earliest for submitting a new bank guarantee shortly.
But where have you stated it is some fraud is played by the third party?
Yes, well. Then they gave us a show cause.
No. Where have you stated?
Fraud later on we have stated that.
Why later on? What should be informed? If you wanted to exculpate from the process, what the Lord Coke said, if they are the fruits of the poisonous tree,
Yes.
you need not be planted. But the effects of fraud, the Lord Coke, Edward Coke said, and Lord Atkin repeated, that they are fruits of the poisonous tree.
True, man.
Therefore, you cannot.
I cannot enjoy the fruit, my lords. I cannot enjoy the fruit.
So not only you,
Not only
there
me,
cannot be
I also
made.
cannot. My lords, certainly it was a fraudulent document. I said it's a defective document.
No, that itself shows that you were not fair with the others.
My lords,
You should have said in all places, sir, it is fraud. If genesis of the fraud is there, I am also a victim.
no, we have said it, my lords.
No, you said it afterwards.
I said it, my lords.
But I should be fair to the court.
My lords,
Let's clear it out.
no, I'm just I'm going, my lords, in a scheduled manner, my lords, so that your lordship understand. Thereafter, they gave us a show cause notice that why your contract should not be, why action should not be taken. They suspended us, and we immediately replied to them.
But let's see it, okay. Kindly see what the apex court said in P. Changalavaraya, SP Changalavaraya Naidu versus so and so. Take out that judgment.
Man,
Kindly see that. Then not
no, my lords, I am only placing the facts before your lordship.
correct. But I'm telling the law to you.
No, my lords, here my case is
That SP Changalavaraya Naidu versus so and so. Look into that judgment. I may help you.
getting into it.
1994 AR 853. Ask your
My lords, see,
take note.
Yes.
When judge says very humbly,
my-
you should. Otherwise, I have to confront you with that judge.
no, certainly.
That situation.
Your lordship can look at my conduct, my lords.
Take out another thing. Meghamala versus so and so. You
My lord.
should have said at the earliest point of time, sir, I am not a party to the fraud. I am also taking shelter under the leaking umbrella. I will stated in your first letter. You said by mistake you wanted to just cover up that. You knew because you made inquiry through your employee.
Yes.
The employee came back and reported to you that there is a perpetration of fraud, fabrication, etc. You did not say that. Where is your employee's report?
My lords, employee lodged an FIR.
Which date?
And the complaint was lodged.
Is it complaint or FIR?
Complaint was later on turned a complaint before in Bombay they first lodge a complaint. The police investigates whether there's a prima facie case and then turns it on an FIR.
That may not be correct, but I have to tell you, complaint means the one which is defined. And if it is given under section 200 of CRPC, then alone complaint. Therefore, I am asking you, there are many consequences.
No. Here, my lord.
Then on which date FIR was lost? It's FIR.
My lord, 6/4/25 at 2:45.
6/4/25.
Lodged.
When did you send the letter to the bank, to the other side?
On 3rd.
First letter.
First letter on 3rd. 3rd of April.
3/4.
Yes.
May I just have 2 minutes? My learned senior would also be apprised. We have given those documents in counter.
Yes.
At 10:13 a.m. on 3rd of April, we write to the bank to confirm this bank guarantee. At 10:29 a.m. on 3rd of April, the bank says that it is fraud. And thereafter, all these things have started from there. And we immediately intimated, well, these documents are there, very much a part of the record. By 10:29 a.m., it was clear that this is a fraudulent document.
But he was not a party to the fraud. Is his submission.
Well,
He is a guilty party because he did not stand bare before you.
well,
He should have said, there is a fraud, other persons have committed, we have lodged a FIR, this we want to tell you, and we want to show bona fide, take new back guarantee. That is not their
That is not. This is an afterthought.
No, this is not an afterthought. How do we know that they have sought clarification at 1029? Because the PSB, we are not connected with PSB.
No,
This is a fraudulent bank guarantee.
Why
given
did you
to
not
us.
tell the other side? All this.
My lord.
You knew this.
No, we have given an FIR immediately within 3 days, my lord.
No, even before that you received the information.
Yes, my lord. We have received the
And
information.
that information you did not disclose to the other side.
My lord, this is the letter we have given. I cannot.
This is not a case of some land tiller
No.
or a pressure clause, some scheduled tribe man.
No.
It's a yours is a company.
Yes, ma.
Huh?
Yes, ma.
It's no company. But many amount is involved, heavy stakes are involved. Unless that is done, not only deterring you, they want to deter others who will do like this. It is not that you did.
I understand, my lords, but here I was part of the fraud, my lord. I mean, I was a victim of the fraud. Now,
That you should have stated. I am also.
You have stated.
No, in the first letter you are insisting contrary to your records.
No.
Perhaps I have.
My record, this is my
the
first letter.
Letters.
Yes.
If I write the order,
Yes.
I have to highlight that you insisted upon that your submission, which is contrary to records.
No, my first letter was this much. Certainly, this is my first letter.
Stand to the fact.
And thereafter, my lords.
Always accept. See.
No, I accept it.
Ruhat, Ritam Ugram. Whatever. If it is true, accept it.
Yes, my lords, I am accepting it. I'm accepting it.
You are hiding away.
No, I'm not shying away from this letter. My lords, first time I placed it before your lordships. I'm not hiding away from this letter. This is my letter. This is a matter of record. I cannot shy away from this letter, my lords. Thereafter, when they gave me a show cause, I explained the suspension letter, my lords.
No, I'm asking a simple thing now. I don't go to that level at all. That hearing, perhaps these are the only points.
This is the only point.
Then matter is heard.
My lords, before I get into the other aspects, my lords, I'll see what is there in the counter.
First, I'm hearing you now.
No,
the first point you have completed now.
No, I'll see the counter, my lords.
Then
I'll have to take instructions. No, I was just praying for stay, my lords.
No stay. Learned senior advocate seeks reprieve against blacklisting of his clients in WP number so and so. Yesterday, so this is WP now. First, kindly be seated.
Second one. Yes, because the second one is first in point.
Second one is first. First one is second one.
Above one is yes.
Above one is the director's one.
That's second one.
That we will place one.
That's what. Kindly be seated.
18,264.
Basant. No seat. Why in our court?
Seats are there.
Frugal already.
No, seats are there. Seats are there. My learned senior.
Field seat to senior advocates. Please. Thanks. Heard. Recall that order. Heard learned senior advocate Shri so appearing for the counsel on record for the petitioners. And also learned counsel who is on caveat for respondent. All respondents.
State authority of India. Sole respondent.
That's correct.
Sole opposite part.
A cursory look at the case papers shows, and that is not disputed from the side of the petitioners in all fairness, that the subject guarantee given to the OPs was a fabricated stroke fraudulent document. First off, this aspect, according to learned senior advocate appearing for the petitioner, was brought to the notice of the OPs, offering to give a genuine bank guarantee in its state. Why the letter dated?
My lord, 425 Annex 6.
3/4/2025, a copy whereof avails at an exercise. First off, a bare perusal of this, does not in so many words, tell or indicate the fraud, the perpetration of fraud or fabrication from the agencies from which petitioners claim to have procured the setback guarantee. First, that senior advocate submits that even his clients are the victims of fraud, and therefore the fraud in Kochian sense cannot be attributed to the petitioners. First, next paragraph. Learned counsel on caveat points out that in the earliest letter dated 3/4/2025, the petitioners had offered to furnish a fresh bank guarantee issue. However, the letter is conspicuously silent about the perpetration of fraud or forgery, may be attributable to the agencies. And therefore, a person, whether he is a victim or perpetrator, cannot take the advantage of fraud of others committed on a particular party standing in a particular legal relationship. First, next paragraph. Having heard learned counsel for the party that having perused the petition papers and also the application seeking reprieve, this court is of considered opinion that no reprieve can be granted at this stage to the petitioners in the light of apex court decision in SP Changalavaraya Naidu versus so and so and so, and Dilip Singh Meghamala versus so and so. What is that judgment? Meghamala Saho versus State of Odisha. No.
Here, I have given the hard copy. SP Chengaravala Naidu is 1994, 1 SCC page 1. And Meghamala Melods.
Narasimha Reddy.
And this one also, Dilip Singh Melod knows.
That's all.
Dilip Singh has the opening lines, Melod.
No. In Meghamala versus G. Narasimha Reddy. Citation to just right now. Okay. 2010, 8 ACC 383. First one. It hardly needs to be stated that fraud in commercial transactions will have havoc and affect the credibility of the parties to the same. First off, fraud vitiates everything. Road, Lord of Edward Code, centuries ago. First off, arguably, although not conclusively, this court finds some elements of culpable conduct on the part of the petitioners in not disclosing to the other side about fraud and fabrication of the subject bank guarantee, as rightly contended by aviator's counsel. First off. Next part. In the above circumstances, IA number so and so, in WP number, first W number so and so is liable to be and accordingly rejected.
But I have another IA. The termination, they have terminated my contract. That may be taken as part of the record. For amendment, my lords, I'll file a consolidated. I've served copies on them also. We will file a
We'll allow that application initially.
Yes.
Next, in another matter.
So that would be.
No, in this matter, termination. This is the second matter, which now the company's case.
Company.
Yes.
May I just assist your lordship with the IA numbers? IA number 1110002 of 2025 is for stay. Another IA for stay is 14,235 of 2020. So two IAs for stay can be disposed of.
Both the application are disposed.
And amendment would be 13,800.
The other part. Orders on amendment application in IA number so and so in the second
Months. Termination maybe.
Next part. Petitioner company which has suffered inter alia blacklisting has moved this application seeking to add additional prayer supported by the grounds as to invalidation of as to rescinding of the contract. Termination of the contract. Termination of the contract. Which is the right word? Is it rescinding or termination?
Their yes, termination.
Contract in question. In fact, it is linguistic and it is legalistic also. The great authors like Frederick Pollock and Mullah on contract, they use the word termination.
Termination.
But in English law of contract, like Cheshire, Fifoot and Formston, like another A.G. Guest, Anson's law of contract, Chitti, they use rescission and termination of contract mutually exclusive. And this is for law students who are sitting in my court.
Termination has different connotation in service law.
But termination of service is another thing.
Yes, dismissal and termination, two different concepts.
The discharge. All right. The application is supported by the affidavit. And it is moved at an earlier point of time. First time. The subject matter of the application and the essential subject matter of the petition have a continuity and relevance. First time. No prejudice will be caused to the other side if this application is favored. Conditionally. You give about 10 books to the library. Yes, conditional. First time. In all fairness, the Caveators Council, although initially opposed the application, now agrees that application be allowed and leave be granted to amend the petition as sought for 10. First times. In the above circumstances, the subject application having been favored, leave is accorded to the petitioner company to effect amendment to its pleadings in the petition and file a comprehensive petition within 2 weeks.
Within one week, by next.
We'll give you 2 weeks, but you do it within 1.
Yes.
Within 2 weeks, after serving a copy thereof on the other side. Subject to the condition that the applicant company shall present the following 10 books to the advocates library, some name is there.
Library.
Madhusudan. Sorry, write down the book first. No. One, Law in a Changing Society by Professor Wolfgang Reitman. Number 2, Patent on Jurisprudence. Number 3, Law and Legal Reasoning by Julius Stone. Number 4, the Judge. And another book, The Advocate by David Penick. They are good books. Yes. Okay, both are David Penick. Next. Courtroom Genius by A.B. Datta, right? Soli Sorabji and A.B. Datta. Next, Palkiwala, The Man by M.B. Kamat. And next, the Supersession of Judges, Kuldeep Nair. And how many books are over now? 10 over? Other 3. Okay. Courting Justice by Shanti Bhushan. Then next one. We the People by Palkhiwala. And last one, Before the Memory Fades by Nariman. Within 4 weeks.
Provided that some books may not be available, we'll order it online.
That all books are available. Yes, all books are.
No, just maybe our stores may not be there. Then we'll have
there is
4 weeks. I think yes,
in fact, we are grateful to your lordship. This judgment, your lordships would like the language here that the Dilip Singh, where they have said that what is happening now, and they have quoted Buddha and all. So just for your lordship's reference, we have given a copy.
Just give that copy. Keep it up.
Your lordship would like.
Some of it I just kept my attention.
No, your lordship must be aware, because we have also got your lordship judgment from Karnataka on this. But Dilip Singh
was a matter relating to bank.
Dilip Singh opening.
It was a bank guarantee.
Bank.
I remember the case. That is Nitesh Estate versus so and so.
Well, that's one, and then one was John Rajkumar JT.
Yeah, that were 2 judgments.
But this Dilip Singh is something your lordships can see, the opening lines.
Yes. Thank you.
1 and 2, para 1 and 2 are really nice.
This shall not be reflected while we take up the matter on the main merits.
We are grateful to.
It is made clear
These are
that the observations herein above made being confined to the disposal, not this, the first one. Shall not reflect on the main matter when it is taken, when they are taken up for hearing.
The first matter is a totally different case, my lord. It's by the directors, my lord.
That you are yesterday you said Solomon.
Solomon. No, actually, what happened, my lords? I was to cite a book on Salmon's jurisprudence in another court, my lords.
It happens.
It happens. Subconscious, my lords.
Yes, it happens because Freud, Sigmund Freud.
Yes, my lord.
It is.
I'm a student.
Lips.
I'm a student of psychology. I've done my MSc in psychology.
Yes, I like that subject very much. I have read a few books on that. That Freud's interpretation of dreams. And Carl Gustav Jung,
yes,
and Sabina Spielrein, Dr. Mann.
It's a very interesting subject.
Interesting some branch of knowledge.
And we try to utilize it in courts also. My lords, here, my lords, I'll just press for stay insofar as the directors. My lords, this is a public limited company.
Same order. No. I'll break the same order.
My lords, no.
There cannot be conflicting.
We have never been issued show cause, my lords. Your lordships may note this. My lords, it was all to the agency, all to this main company. We as directors.
You want another order to be duplicated? Yes.
We have got Cox and
What applies to them? I will only say, what applies to petitioners will more apply to the company.
My lords, my problem. My lords, at least I should have been. Suppose they're lifting the corporate veil, my lords. They should have given me a show cause.
Company does not act at all.
No.
From the salary,
my lords, our employees are acting. Various officers.
Can it be said? What company? In fact, company law, Chalmers company law. He says company is a legal entity.
Legal entity.
It will not be able to commit anything, right or wrong. It is humans. who do that. That's how, in fact, this aspect is discussed in Cox and King.
Yes, my lord.
Para 90 and 94, this squarely applies to this case. Gratefully, Your Lordship, we have got that judgment.
Well, the thing is, my lords, even if, let us say, they say that we are guilty of fraud, does it not mandate a show cause to me before?
No.
My lords, here I've never been heard in the matter.
Question is not, question of hearing company is nothing but hearing the directors only.
No,
company does not have that way.
No, company, my lords, we are directors on the board, my lords, and we are directors in various other boards, my lords.
Maybe. But
if we are blacklisted, we'll be blacklisted for the other boards also.
It may happen, we don't. You should have been very careful when you are such a big businessman. If it were to be some school teacher or some laborer,
yes,
or say some member belonging to depressed classes, oppressed classes, we would have understood.
My lord, 60 years we have been working. There is no malice on our part, and our track record is impeccable, my lords.
That's all right.
That is exactly what Kulja Industries also says, that you should see the previous track record.
That too you consider when main matter comes, because now only if I say everything.
Yes, ma'am. You may
certainly,
sir.
I said I have not said anything.
Yes.
Merits of the matter. On the other hand, I have protected you.
Yes.
There are some arguable points.
Yes.
I understand.
My lord, may I pray a date may be fixed so that the matter is disposed of, my lord, sir?
Before my memory fades. It is better that my memory fades and matter is heard afresh. Take longer date. Otherwise, I'll remember these things and I may be swayed away by my own impressions. Now I have gathered from what you are working.
May I just
Any day after the
first matter IA, my lord, may in the same light, because Cox and King stares at them.
No,
and these are prima facie.
Let him amend the petition. To amend the petition.
First one, there is no no amendment.
No, second one.
Second one is.
Post after 4 weeks.
Oh,
to report compliant as to giving of books, handing of the above books to the libraries.
Well, obliged.
We are grateful to you.
Item 10.
Item 10, my lords.
Yes.
I pray for 2 weeks adjournment, ma'am.
You want adjournment?
Yes, my lords.
In which matter? Serial number?
10, my lords. For filing the English annexes.
Why English annexes? I'm learning Oriya. It's a wonderful language. 60% of the language comprises of Sanskrit only.
I only pray 1 week after let it come.
Give another reason. You want to go to Martha? Why?
I only pray for an adjournment.
Up to 2 weeks. Very question.
Deeply.
Yes.
Item 11.
Right.
Prayer involved regarding disbursement of some bigger amount, 70,000 towards arrears salary. It was recommended by the concerned DO, page 18, Annex 3, to the director for approval.
They are not acting upon that?
Yes, my lord. So after that, the order was issued from the Sonal Court, page 29, to accord approval. Page 29. But instead of giving approval, the impugned order, the proposal is rejected by the director.
Take notice.
Yes, ma'am.
Lordship,
18, not
1982 to 1991 area plan.
No, series of correspondence, my lord. The original applicant died.
80 to
Why should
1992.
not you put him to argue?
Yes, ma'am.
So that he will gain more wisdom on the next time when the matter is taken.
Yes, ma'am.
Yes.
Highly counted.
That's what. KGA on request accepts notice for the OPs. See, Mr. Lenka. Yes. Now law has marched from April to May and June of its life. One matter I have held. The salary payable to an employee is the property because it is the consideration for blood and perspiration, sweat, which he sheds. If that is property, can you take the property without compensation? I have structured the judgment that way, at least in Karnataka and here also. Yes. Therefore, delay and other things will not agree when it comes to salary part. It is not just a debt. For debt, there is a limitation. If it partakes the character of a property, then it comes to 300 capital A, where he should go. Therefore, state I have not permitted. I have framed such judgments.
Yes.
One in Karnataka, one in your state only. Yes. Accept note. Yes. Number 3. Item 12.
The person is a retired teacher of a Flagler school, which is now at a new at school, high school.
Pension and benefits not given to you.
Yes, Hemant Sotra case, a similar matter has been
How do you get your lordship, all these matters?
Emergent notice. Call along with WP number service. Learned AG accept notice. Right. Next. Item 13.
May I please, madam?
Yes,
The
Dr.
matter,
Saab.
madam,
Which is your thesis in doctorate?
is on protection of domestic protection of women against domestic violence and role of High Court of Orissa.
Okay, confined to High Court. High Court.
Some of the aspects, one chapter is totally devoted to High Court of Orissa.
Yes, I could not read.
I will ensure.
Very. Yes.
This matter relates to the regularization of services. The matter is like this. Despite being serving as assistant.
In the light of Jago, it has to be considered.
Yes, Jago, Vinod Kumar, and recently Dharam
You
Singh.
accept note?
Dharam Singh. And your lordship judgment also have passed 2 judgments.
Next 10 is pending.
No, not it will not serve purpose.
You have made a representation.
Yes.
Repentation,
Consider that.
they may not consider.
They will consider when I make the order. They know what I will do if they do not consider. Perfect. The short grievance, kindly be seated.
Oh, bless you.
The short grievance of the petitioner is essentially as to non-consideration of his representation dated. Your representation appears to have been drafted by you. Dated 11/8/2025, a copy whereof will set Annex 10, wherein a grievance is, a complaint is made as to non-regularization, wherein a request is made for, wherein a request is made for regularization of her services as an assistant professor in business administration in the respondent university. But university is not a part. University is a part.
Yes. Now,
Who appears for
3 and 4.
who ordinarily
They
appears
have
for?
ordinarily.
Who will send that this judgment to the university by spirit? Perfect.
Oh, bless.
Next paragraph. Learned counsel appearing for the petitioner submits that when a representation of the kind does not meet its fate at the hands of answering respondents, this court should intervene. Consistent with the mandate of Article 3, constitutional mandate enacted in Article 350. First off, I agree with this. Next paragraph. Learned AGA, Mr. Lenka, appearing for the OP number
1 and 2.
1 and 2, submits that the essential decision has to be taken by the university and that his client also will send an intimation to the registrar of the university, if a direction is given to consider the subject representation in accordance with law and in a time bound. First of all, in view of this fair submission, and also because no adverse order is being passed against the university, in as much as this is an order to pass an order in the subject representation, notice to university is dispensed with. First of all, next one, in the above circumstances, petition is disposed of, directing OP number 3.
1. Commissioner Secretary.
Commissioner Secretary, he has repented before the Commissioner Secretary.
Yes.
Not before the university.
Now, university, my lord, the position is that the university is the recommending authority. And the ultimate decision is taken by the
you will send that to them also.
Yes.
And you also take a decision in this. Perfect. In the above circumstances, the petition is disposed of, directing OP number 1. And also, OP, which university?
University, OP number 3 and 4.
OP, and also OP numbers 3 and 4.
Vice Chancellor and Register.
Only the registrar of
Register 4. OP number 4.
OP number 4. Why Vice Chancellor is made a party? You are not supposed to. Unless
in the position is the recent, your lordship for kind, which may be helpful for others. Recently, the university amendment has been amended.
Amended?
Yes.
Saying that?
In that amendment, the university has been, the Vice Chancellor has been given power to take some steps, recommending steps in respect of the
grievance also.
Yes, also. And thereafter, the ultimate decision will be taken by the government. Your lordship can
No, that's all right. Anyway, I have that.
This is
give one call.
Yes.
Then keep it.
Your lordship, I have
Okay.
section 22. 22, may I?
The amendment.
Yes.
Yes,
May
I look into.
May
I have got the point now. I have understood what you are saying.
Yes, ma'am.
Okay. That was circumscription put on. Fixing a period of 8 weeks for taking the decision on the subject representation and to inform decision taken to the petitioner in writing. First, all contentions are kept open. Next paragraph. It is open to the answering OPs to solicit information document, etc. So on. First, the registry to send a copy of this order by speed post immediately to the OP numbers 3 and 4. 3 and 4, since you are saying amendment 3 and 4.
Item 14.
There you have to say all conditions are kept somewhere in structure the statement that way.
Obliged.
Yes.
Item 14.
No spots.
On behalf of Mr. D.K. Batra, I may permitted.
Yes.
The petition is a retired Hindi teacher of aided high school. He has spread for
notional benefit.
Yes, notional benefits from 1/1/2016 to 1/10/2017. Yes, well, a similar notice has been issued.
Issue emergence notice. AGA Mr. Lenka, request of the court accepts notice for the OPs. Call this matter along with WP number. Next.
Item 15.
Yes.
The last order, Lordship, may have glanced the AGA directed to take instruction in the matter. Lordship, matter was before the board day before yesterday, Lordship, on Monday.
Did you go through that Kashinatha Dixita?
Yes, Lordship. Grateful for that.
On receipt of the representation on 11.
Other day, Mr. Monty said,
yes.
We will get, he said, matter be posted yesterday only, but I said take one more day.
Today also, I have also contacted today the nodal officer and the district education officer, the PO, and even the assistant director law of the school and mass education.
They are not responding. It's a serious matter. When government advocates tell them, they should simply come and give all the documents. Otherwise, how are you going to defend the matter? It is a difficulty. You are not there just, they are not just your clients. You are the officer of the court.
So yesterday night at 10 o'clock, I got the file. So I could not contact. Today morning, I contacted all these officers.
They are not coming. From whom you want...
that is,
respect the government advocates first, your officials. Who is the highest official as the respondent?
That is the secretary.
Secretary?
Yes, sir.
But if I write something against secretary, will he not trouble you?
No, that is the fact I placed.
Of course, I will protect you. I will fully protect you because you are in disability.
Yes, sir.
Learned counsel for the petitioner presses for interim relief. First up, learned AGA submits that despite his hectic efforts to confer with his clients, official clients, the same have not yielded any fruit because of reluctance of the concerned officials to confer. Personal. The council representing the state and their authorities and its authorities are not just the mouthpieces, are not just their mouthpieces. First off, they are officers of the court, and they discharge their duty in the larger interest of the public. First off, the officials not responding to the government advocates is a serious matter.
This Honorable Court has held earlier also.
Same view.
Yes.
In fact, it may border contempt of court because they're not cooperating comes in the way of discharge of administration of justice. First off, in matters like this, it is ideal to summon the officials personally, if necessary, with the aid of police. First, however, that extreme step is kept reserved only with the warning that the concerned officials should immediately respond to the government AGA, other government advocates. First off, call this matter on Monday. First off, registry to share a carbon copy of this order with the learned AGA, Mr. Lenka. First off, registry shall send a copy of this order to the principal secretary and law secretary of the government of Orissa for immediate action.
Principal Secretary, School and Mass.
And also Principal Secretary, School and
Mass Department.
By speed post before sunset of the day for taking disciplinary action against their
opposite person number 4.
Cancelled officials who did not cooperate with the
opposite party number 4.
Against action against the cancelled officials, including OP number 4, who is said to have not cooperated with the government advocate.
May I pray, Lordship?
Your Lordship has just a glance.
Yes, do that, Judge.
That will be.
There is such a, why they are like that?
Even their Lordship has held that it is contemptuous.
It is contemptuous.
Yes, Article 259.
It is contempt of the court and contempt of the government also.
Yes, sir. In spite of that, they are not.
This court, I will not say you have produced, I will say this court, they should not mistake that you are arguing against them only. This court has also noted the order dated 11/2/2025 made by the other coordinate bench in pending WPC 671 of 2025, where the same anguish is expressed. Okay. If this is on my interim
application.
No interim. Next. Item 16. Yes, sir.
Lordship, I am for the petitioner. Lordship, the petitioner is an employee of.
Can you be a little louder?
Lordship.
Yes.
The petitioner is an employee of Indigo Airlines, posted as a customer service executive on dated 9/4/2012. Lordship, para 3.
Your voice is not audible. Call this matter some other day. After 2.
That's
Then be loud.
Lordship, the petitioner is an employee of Indigo Airlines and posted as customer service executive on dated 9/4/2012.
9/4/2012.
Lordship, all the employees of the airlines has to provided a airport entry permit by the Bureau of Civil Aviation Security (BCAS) due to security purpose. Lordship, that AEP.
They are not giving that.
Yes, that was given.
Following employees.
Yes, no. That was also allowed to me and given to me. Lordship, that airport entry permit has to be renewed in every year, and due for that, it was directed to the local PS to verify the character and antecedent of the employee, and thereafter it was verified and renewed. Lordship, in my case, it was also directed to my local PS to verify the AEP and the character and antecedent of the petitioner, and the local police found that I have 2 anti-criminal antecedent, that is Mahila PS case number 12 of 2023 under section 498A 323 506 34 of IPC, and another PS case number 138 of 2024, that is under section 115 subsection 2 and 85 of BNS.
Yeah.
Lordship, both the cases are pending before Lorna STGM Cuttack, and I was
on the stage.
The stage is now for appearance, and I was on. My wife not attending. That matter is purely matrimonial matter.
No, you can't say like that. They may take when you have a matrimonial case. It begins with matrimony, but may go to it may cross the borders of the country.
Lordship, the stage is now for the evidence stage, and I was under the 41A notice. The stage is now evidence stage. Lordship.
41 is CRPC.
CRPC.
Appearance notice.
Lordship.
Yes, their credentials are doubtful. It appears to be between the spouses. It is not that simple.
Lordship, after due to the criminal antecedent, Lordship,
they rejected it.
Yes, the BCS notice to submit the AEP before the VSS, the security officer.
From the criminal case, you will be allowed.
Lordship, my submission and prayer is, Lordship, the matter is purely matrimonial matter.
Yeah.
Lordship, the matter arised due to my wife has elicited relationship with his cousin brother. Lordship, I'm not going to the matter, but I am just putting. Lordship, due to that, I was objecting to not to have illicit relationship with that person. Due to the vindictiveness, my wife lost 2 years.
Not no. The criminal case is criminal antecedents. How Apex Court interpreted in criminal extension that democratic, which is that Association of Democratic Rights 2002 Supreme Court. It's not that simple. If a person does not treat his wife and children with respect, what is the guarantee that he will treat other persons with respect?
Lordship,
498A.
Lordship, the child is living with me. Lordship, due to illicit relationship, only the matter arises.
We do not.
Lordship, in 2000.
There are 2 criminal cases against
Lordship, may I?
One more point. Let's say in 2023 PS case, we have been compromised, and my wife again lived with me, for which he in the compromise petition he has stated I will withdraw the PS case. But later he has not withdrawn the PS case, for which the criminal antecedent showing against me. Lordship in 2024 against the same offences, she lost the PS case that is 138 of 2024.
How can we see criminal antecedents mean? Not necessarily conviction order in matters of employment.
Let's say now, in the meantime, before I filing the petition, let's say that writ petition, my father has been died, and I was completely under all the responsibility of my family is upon me.
Find out some jobs. Even I have lost my father, mother. Let's need to be a ground. You should have been more humane. You are not humane to your wife and children. Allegedly, we do not know the truth actually. Truth only God knows.
Let's say the matter is in the evidence stage. I was trying to solve the matter in the before the
solve and come. Otherwise, I have to pass order now.
But let's see, my wife is not cooperating and not presenting.
I will request the court, the criminal court, to expedite the proceedings. That will help.
She is now living with his cousin, her cousin brother in another state. Let's see.
Only that brother. Only the objective. See, let's see. Have seen what happened Twin Towers. The employees of airport. They were working with some other person. The two towers fell down in America.
Let's say
so many things are happening now. Therefore, we have to be explained in this matter. We should leave certain things to the wisdom of the officials.
Let's say I have one more point. Let's say during the they have sent me the email to surrender my AEP, but during that they have never heard me. They never allowed me to file the show cause for that Bureau of Civil Aviation Security. They never allowed me to submit my show cause or anything before them. Directly they have sent me
cause of action.
They directly sent me to surrender the AEP. Let's say I may be allowed to submit.
No, so it cannot be. If the persons having criminal antecedents should not gain entry to the airport. You have seen what happened in the recent past.
Let's say
we cannot say now at this stage. It is material. We should leave certain things to the opinion of the executive. The Great Court cannot run race of opinions with the executive. I cannot run a race of opinion with that.
I only pray, Lordship may allow me to submit my show cause before the authorities. So
but
that
the period is over now.
No, the period is not over. Only the period, to surrender the EP.
Then you withdraw this petition. I will permit you to file your representation to the concerned office.
Before that, the time before I surrender, let's say before I submitting my show cause to the authority, let's say in that meantime, they will the period will be over. The time period will be over. Let's say I'm submitting to and praying. Let's say may grant me to stay the procedure, and I will submit the
staying.
Let's say
you do not know what your client is. They know because you have not come to court. But you operate in the airport.
Only
they will have information. Who should be alone? Who should not? Because otherwise, safety of all those who travel.
That's why I was promoted. I was posted in 2012. Thereafter, I was promoted also one time.
Maybe.
I have no other offences or any criminal
offence against the wife is what is that?
Only that is arise due to the illicit relationship what I have observed.
No grounds to interfere. Rejected. A copy of this order be sent to the office.
Let's say I am permitted to withdraw.
Matter having been heard at length, is permitted to be withdrawn on request. First off. Next, in view of the above, petition is go to prayer column. the order dated 22/5/2025, a copy whereof will set an excerpt 5, wherein is a claim for arrears of salary during the period between 1/6/1999 and 1/6/2011 has been litigated. First off, learned counsel for the petitioner submits that the impugned order was passed in the light of WPC 15658 of 2020 between Harap Prasad Ray versus State of Odisha and others, disposed of on 21/4/2023. And now the writ appeal number 1350 of 2024 having it reversed the judgment.
No. It affirmed the judgment. Direction was there.
Having affirmed the decision of Haraprasad Ray Supra, matter requires re-examination. First sentence you said, what is board of? 23. 23. And writ appeal number 1350 of 2024 against the same was paid at that time. Now it's not necessary. First, the said writ appeal having been disposed of on 17/7/2025 by the division bench, the entire matter requires to be re-examined at the hands of OP number. Sit down and all. 1 and 2, my lord, because OP numbers 1 and 2. Next paragraph. Learned ASC on request accepting notice for the OPs in appreciable fairness submits that the impugned order be set aside so that a fresh decision can be made by the jurisdictional OPs in view of affirmation by the division bench of the order of the learned single judge in the subject cases as mentioned above. First one is, however, he puts a caveat that all contentions of the party should be kept open so that a decision on merits would be taken by the jurisdictional votes. First, with this proposal, the learned counsel appearing for the petitioner is agreeable. Next paragraph. In the above circumstances, this petition is allowed in part. The writ of certiorari having been issued, the impugned order dated 22/5/2025 at an excerpt A5 is voided with a direction. Voided. First off, matter is remitted to the portals of OP numbers 1 and 2 for consideration afresh within a period of 8 months, which will include conveying the result of consideration to the petitioner in writing. First off, all contentions are kept open. Next one, it is open to OP numbers 1 and 2 to solicit any information, documents, or exercise. However, subject to right. Where copy to be, no course. The copy to be acted upon. God bless.
I may pick pattern. Let's say item number 16. I have written the matter. Let's say a time frame may be given to dispose the matter that was criminal matter before STJM.
What you have done? Yes, sir. Full stop. Further, counsel for the petitioner justifiably says that the criminal cases pending before the jurisdictional criminal courts may be directed to be tried and disposed of at the earliest, first term. This court agrees with the same.
Let's say maybe in 3 months.
Yes, I cannot put because I do not know what is the pressure on those courts. Agrees with the same. First, petitioner is permitted to. After that, this code of petitioner is permitted to place a copy of this order at the hands of the learned judges of the criminal courts, wherein what is that? What is that? The case number? Something.
Let's see.
Write down and give here.
Let's see.
Right.
Let's see. Okay.
For consideration. Okay.
Item 18. May I please your lordship on behalf of Mr. Devendranath Mishra Major. The petitioner is retired demonstrator of Botany Department in Salipur College, claiming for UGC scale of 12 matter. In this regard, our Honorable High Court has already disposed of matter. WPC number 26. Annexures 17, my lord, page 89. I have made a representation on this regard.
Annexure 17 is your representation.
Annexure 17, my lord.
18, 12.
24.
What you have sought for there?
And claiming UGC scale of pay.
In the light of which decision it is?
In the light of
Apex Court.
Apex Court already confirmed our High Court judgment, madam.
Gitanjali Mishra.
But
yes, brother, confirmed by Apex Court also. You consider the representation. Right now. Short, kindly be person to. Yes. The short grievance of the petitioner is as to non-consideration of his representation dated 18/12/2024, a copy whereof awaits it annexure 17, wherein he has requested, which authority have requested?
OP number 2, my lord.
OP number 2 to extend to him the UGC pay scale and pay the arrears in the light of decision of this court in Gitanjali Mishra versus is it state? Gitanjali Mishra case was against state? Other somebody cited.
Samarendra Naik versus state of Odisha.
In the light of
in the light of
annexure? Which is your annexure judgment? Have you produced that?
I am quoted in my para. Page 18 of my read petition, para 30, my lord.
Gitanjali Mishra versus state of Odisha and others in OJC number 8516 of 1992, disposed of on 30/4/1993, which came to be affirmed in the said decision has been affirmed by the Apex Court in Civil Appeal number 5426 of 2006, having travelled to this court earlier. First. Next one. Learned AAC, on request of hearing for the OPs, very fairly agrees that he would instruct his clients to look into the grievance of the petitioner as has been reflected in the, projected in the subject representation in a time-bound way and in accordance with law, keeping in view the decision of decision in Gitanjali Mishra Supra, if all contentions are kept open. First, counsel for the petitioner is agreeable with this fair proposal. Next paragraph. In view of the above, petition is disposed of, fixing a period of 8 weeks for consideration of the subject representation and to inform the petitioner the result of such consideration in writing. First, all contentions are kept open. Open to solicit information document. No course. Yes.
I don't see.
Yeah. Can I come back within a couple of seconds?
Yes, please.
Yes, fine.
Item number 20. Teacher transfer matter.
It's a transfer matter. You have given a representation. You have not given representation.
My lord.
Why two orders 11/7/25 and 13/5/25?
It is a cover matter. Earlier,
That's not it. I'm asking two orders you are challenging.
my lord.
You are seeking certiorari, mandamus, so many things you have sought for. Certiorari would have been sufficient. Anyway, for nobody will charge you if you use more words. It's true. No problem. 11/7/25 is one order.
My lord.
This order
It has been relieved from 11/7/2025,
11/7/25.
my lord. Page 36.
To his place, any other person is appointed.
No, my lord.
Huh?
No, my lord.
Where have you stated in the petition? No other person is appointed after you have demitted office.
Okay. Not instruction, everything. But in the order itself, you directed to join the leave assignment by 12th July 2025. In the second paragraph, the above 10 teachers of this block are hereby relieved on the forenoon of 11/7/2025.
11/7/25, there has been
Unable to join them in their new assignment by 12th July 2025. Meanwhile, my lord, near about 2 months.
no, whether any vacancy was created there. Any other person is transferred from that school to another school or to this school.
The present petitioner has been transferred from Utta Angapur Primary School to Satyavadi
High school.
Kurpasinpur, my lord.
80 kilometer distance, my lord.
No, that is there.
No, whether some student should not suffer, na?
This is transferred to person the letter, but the guideline of the MLMP.
MLMP is all right.
That's true.
But now question is you are
no one joined that school.
If I say that, what the children should do?
No, he's not joined that school.
That is the problem now.
He's on the leave.
Huh?
He's on the leave, medical leave.
He is on medical leave. Best way is to apply medical leave. No, what should children and if there is no teacher?
But I will take instruction.
You are certain, take already AC requested to accept notice for OPs.
My letter, similar matter is pending on next week.
Similar matter is pending on this matter along with WP number
20875.
20875
Of 2025.
of 2020. But you go and report do it for duty now. You can't put the children to the difficulty by transferring, staying all these transfers. First off, petitioner is directed to report for duty at the transfer place immediately so that the students in that school are not put to difficulty. Okay. If he does not obey this order, his petition will be dismissed on that ground itself, regardless of what would happen to other matters. Okay. We will go and report duty first. Yes.
Item 21. Please.
This, we are not giving the relief to you. Do you know why? Because your pleadings are imperfect. Number one, you have not stated what is the retention period. Number two, you have not stated what has happened to that school in your absence. Nothing is stated. Yes.
Wait. Before limited period, before let's say petitioner now retired, he challenging the is granted before the tribunal, but it is still pending in 22. So I pay stipulate time fixed for hearing. It is ready for hearing, but it is not taken for hearing.
It's
before the educational
Early disposal.
Short grievance of the petitioner is against long pendency of his GIA case number 133 of 2022 on the file of State Education Tribunal, Bhubaneswar. First up, learned counsel for the petitioner submits, and this court agrees that right to speedy justice is a facet of Article 21 of the Constitution of India as observed by the apex court in a category of decisions. And therefore, a direction to the tribunal for early disposal of the said case is warranted. First up, next paragraph. Learned AGA, standing tall at the bar and fair to, agrees to instruct the presiding officer of the tribunal to hear and dispose of the subject GI case as expeditiously as possible, and in any rate within a period of 6 months.
Amen.
Next paragraph. In view of the above, petition is disposed of, keeping open all contentions of the parties. First up. Next paragraph, it is made clear that no private party in that case. No private party in JIA case. No private party.
No private. Only government.
Okay.
Department is only for.
Governing body is there.
The registry contains a copy of this order. To OP number
5 and 6.
OP numbers 5 and 6. 6 by speed post. Okay. Web copy to be acted upon. Next.
Item 22.
Your Lordship, I am praying for an adjournment.
Your case is weak, voice is weak, prayer is also very weak. Very difficult to. All right. 4 weeks at the request of.
Item 23.
Petitioner challenge the order of rejection and exert 6 miler for promotion.
Promotion is rejected on what ground? From trained graduate to
level 3 and level 2. Digital level.
From level 3 to level 2.
Miler.
On what ground it has been rejected? Go to the order.
Annexure 6, page 21.
What are the reasons they have assigned?
They were taken the ground para page 27. In view of the factualities of the petitioner's claim does not conform to the applicable rules, government resolution, notification, statutory provisions, and judicial precedents. As a result, the petitioner request for giving a promotion from level 5A to elementary education service by surpassing to level 5B and level 4 service to level 3 or level 2 of elementary education service by counting the schematic period of service from 2011 to 17, that is a period of Shiksha Sahayaka and junior teacher taken together. purely private, did service from 99 to 2009. The school where the petition served was running privately managed by local people and no GIA has been released, which is...
no GIA is released to the school in question during the relevant period.
I'm claiming I'm from in the regular process of selection, I have selected mine.
Correct.
And I'm discharging my duty. When the government taken decision to upgrade the school where a petition was served, that's why it's a region and another government school mine. I am claiming that period taken into together and taking into account my total period of service. My case may be considered. But
you had worked in other school also?
Mile.
But it is for the reasoning paragraph.
We'll file count with my lords because
issue emergent notice. Learned AG is requested to accept notice for the notice. Any private party?
No.
Kind of reasoning. You see this so nebulously saying which section, which rule. They should be state that one, without mentioning which provision, just saying that 2009, 14, 19 rules. Means what? Anyway, next. Item 24?
Pardon, my lord. No, item number 18, my lord.
18?
Your Lordship, detected as the light of Gitanjali Mishra, that is, my lord, Samarandra Naik, the represent number is 26692.
Therefore, I doubted. Which is that you have written Gitanjali Mishra, na? And that Samarad, which is that?
WPC number 26692 of 2000.
Which paragraph?
Paragraph 30 and 31, my lord.
For your representation or petition?
In my representation also that is there.
You have mentioned that. Just
30 and 31 paragraph.
Okay. Yes. Item 24?
Item 24, may I please, Your Lordship? Your Lordship, in this writ petition, the petitioner is praying for the grant of the arrear as per the UGC scale of pay, Your Lordship.
Accept notice for respondents. Connected with, call this matter along with WP number?
Your Lordship, WP number 21845.
21845 of 2025?
2025. And Your Lordship, item 29 is also similar.
29 also same?
Yes, Your Lordship.
Item 25?
May I please, my
Yes,
lord?
Your Lordship.
The petitioner was appointed as Shiksha Sahayak way back into 2008, my lord, and it's 1 page 19. 2006, my lord. After verifying all the records by facing regular process selection. Thereafter, after the scheme under Annexure 2, is have been regularized in 2014 by the collector both. After verifying all the certificate, everything. While continuing,
why you are sought for Paul Anthony? Any criminal cases also there?
Yes, that they have the law affair. Now they are initial proceeding. That unless Annexure 3 Annexure 3 without any notice, Annexure 3 they are dismissal service. Page 22. On the plea that there is a allegation of fraud of the HH certificate. Annexure 3
certificate.
There is allegation of fake certificate. No notice, nothing. Still a dismissal service.
No criminal case is pending.
No. By that time there is no criminal case. Criminal case initiated on 2022. After I approached my lord twice, my director to take a decision on my appeal. They have directed they decided that there is no procedure followed. That is my last annexure, my lord. Director also decided that, but director to take action after law. Now thereafter they have initiated the proceeding. They have lodged FIR annexure 11 page 44. FIR 1 from 22. The self allegation, now they are initiated proceeding. For that reason, I approach my lord to stay of the department proceeding till at least the conclusion criminal case.
Why?
Because department of the self allegation, we have initiated criminal case. Even dismissal service without any notice to me.
Correct, but that happens. That
without any notice, they have. So
But law has developed after Paul Anthony.
Paul Anthony said that if the same allegation, criminal case and vigilance and deportation proceeding, so should have a delay because I cannot compare to the disclosure and defense because that is against me in the criminal case. For that reason, up to decided that there should have till the conclusion.
That's not the law. That's not the law.
But
Anthony has been watered down to a great extent.
that means
Subsequent decisions, which Samaraditya Pal, just other day I read in his book, Paul Anthony is watered. It is not that way. Even in Paul Anthony, paragraphs have been made. When to stay, when not to stay. It is not that merely because you are asked.
they are also decided if the same allegation, at least both are same. There in that case, you should because I cannot be compared to disclosure and defense when the criminal case is pending.
No, it's not that. That is not that way.
That's
not that way.
That is the my lord.
Not that way. That is one of the aspects. That's all.
Yes. So you have dismissed your service without any notice to me. Twice you have verified my certificate, found genuine, they have appointed me, regularized thereafter also, after 6 years. After 8 years, I have a regulation from 22 without any notice to dismiss your service. And that's 3. No notice, nothing. By rule 15, gross rule 15, I will article 311. No notice to me. I upload my law.
Slowly, give one sentence. No, you don't have in your road no speed breakers.
Sorry.
When you come from home to court.
Sorry. That annexure 3, my lord.
3.
Page 22.
They have removed you.
Removed.
Without any
notice to me.
Any notice, no inquiry.
No inquiry.
Is it true?
My lords, kindly turn to page 43. It is a case of submitting false fake certificate.
Where have you had no inquiry?
My lords, kindly see, this is notice to show cause. This is 13/8/2025.
Yes.
Annexure 10, my lord.
No, but you have dismissed him.
My lords, here, your lordship kindly see last, you hereby called upon to show cause reply to the understanding with 30 days from the receipt of the letter, which action shall be taken.
What action? Earlier was when it was you were removed from service?
And so 3 page 22 on 31st August 2022.
31/8.
My lord.
What happened to that order?
That dismissed, I approached my lord.
What happened?
My lord directed to file appeal before the opposite, but not to appellate authority.
Okay. Then appeal, what happened?
Appeal they have rejected.
Rejected.
They are in the appeal. After the appeal, my lord, they have decided that is appeal filed by the issued by the order by the opposite party number 2. That is my lord page.
No, whether termination order was set aside?
No. Not set aside. Annexure 9/7 page 34.
But they are holding inquiry against you.
Again, they are without reinstating your service, again they initiate proceeding.
No, reinstatement is another thing. Whether impugned order, the order of termination is set aside?
No, termination, my lord directed to take a decision by the director. Director, Annexure 7, came to finding that procedure not followed.
Where is that? Annexure 7?
Page 34, my lord.
And therefore, what he did?
And therefore, initial proceeding. Last
They have
paragraph.
taken a decision to hold the DO inquiry.
Yes. The since the petitioner submitted fake certificate, it was observed that process not being followed to dismiss the petitioner from the dealing teacher. My submission is that has passed, till then they are not issued new service, and they have initial criminal proceeding against the same allegation. After dismissal, after 3 years, that order was passed by the director of 24, my lord, Annexure 7. When I prayed for reissued service, now they have issued the second notice, another notice, so notice. That is my grievance.
You show cause. Why? What is there?
My grievance is that, and the show cause kindly Annexure 7, Annexure 10 page 43, not a single document submitted to me. Kindly see.
You get documents and do it. We will direct them to give all documents to you.
My submission, how can I go and tell same salary?
Nothing will happen. It is not 302. Whether the certificate is fraudulently obtained or not, how you will be prejudiced?
That is my submission is that.
Assuming that you will win in the criminal case, you mean to say that you will get the clean chit in the disciplinary inquiry?
Yes, but once that is the law of the now the Ramlal case as well as
That is not that if it
two decision that if on this
honorable acquittal, not otherwise. Ramlal only where there is Ramlal is already considered in PV Rudrappa.
Last Pratap case, P. Rudrapal case, that the lawsuit decided that this is peculiar CBI inquiry there. But in other cases, if a person is acquitted in some same charges, the punishment will go. There also the punishment will go. So therefore,
essential. No, I do not agree. You first you both the essential grievance of the petitioner is against the parallel proceedings, namely one in disciplinary inquiry and other in criminal case in respect of alleged fraudulently secured cash certificate.
HSC certificate, take certificate,
HSC certificate.
Take certificate.
First off. Next paragraph. Learned counsel for the petitioner, heavily banking upon Paul and Dhoni, submits that when same set of facts are involved in a disciplinary inquiry and the criminal case, come on, at least the disciplinary inquiry has to be stayed so that his defense, kindly be seated, his defense would not be prejudiced in the criminal case. First one. Next paragraph. Learned AGA appearing for the OPs vehemently resists the petition, saying that it is not a thumb rule that in all cases where parallel proceedings are going on, one of them should be stayed. First one. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter in as much as the vehement submission of learned counsel for the petitioner that his client would be prejudiced in the disciplinary inquiry if the same is held pending the criminal case it does not impress this court. First off, there may be extreme cases where the Paul Anthony ratio may be invocable, and this is not one such. First off, what prejudice would be caused if the disciplinary proceedings also go on simultaneously with the criminal case is not demonstrated. First off, law of the realm or the ratio of a decision cannot be invoked divorcing the facts, factual foundation. First off, it was Lord Halsbury who said in Quinn versus Ledan, 1901, HL signed so that a decision is an authority for the proposition that is laid down given fact matrix, and not for all that which logically follows from what has been so laid down. First off. Next one. In the above circumstances, petition being unworthy of merits is liable to be accordingly.
I have one pen. They are not supplied documents. That's also documents may be supplied. Yes, my lord.
However,
documents may be supplied.
Petitioner is permitted to seek the documents so that he can put forth the effective defense in both the proceedings. about the proceedings. In this connection, the jurisdictional OP will cooperate.
OP number 4, my lord.
OP number 4.
Sorry, 5, my lord. OP number 5, sir. OP number 5 are supply documents.
I think we have said that. Okay. Okay.
Item 26.
Yes. May I please, Your Honor?
Yes.
The petitioner is a class 4 employee.
Yeah.
My lord, he has sought for his transfer to Mayurvanj district. He is now continuing in Bhadrak district. And
Transferred on which date?
my lord, he is seeking transfer.
He is seeking transfer.
He is seeking transfer to Mayurvanj district because he was appointed under the rehabilitation assistance scheme.
When?
Since in 2016, on 34 2016, because there was no vacancy in Mayurvanj district. His father was a teacher. And therefore he was given appointment in Bhadrak district. Because of his ailment of his wife, he has made a representation to the
What is the ailment?
ailment. His wife is suffering from, his wife is a chronic neuralgia patient. You also may kindly turn to Annexure 3. I have given the medical
name also.
Yes. Medical prescription I have given.
No, by prescription I will not be able to know. If you tell the disease, I will be able to.
Yes, that is. In his representation, he has stated, Annexure 3 at page 16, that his wife is a chronic neuralgia patient.
Neuralgia is a class of diseases. It is not one single disease.
What he has written. And he has applied in the prescribed form, that is at page 17.
In that place, you don't have the facility for treatment?
Well, his wife is staying in his village. His wife is staying in the village. And your Lordship may kindly turn to Annexure 6 at page 20.
Is there a night watchman?
Yes.
No, sorry.
And he has already spent 9 years of service in that school. And under Annexure 6 at page 20, in similar circumstances, the district education officer Bhadrak has also recommended some cases to the director secondary education for transfer, because the director is the competent authority to effect transfer.
No decision is taken on the representation?
Yes, no decision has yet been taken.
Just take decision. Short grievance of the petitioner is as to non-consideration of his representation dated to June 2025. Kindly be seated. Yes, 25. Wherein he has sought for his transfer. From which school, Mr. Smith?
Well, that is, he is presently continuing in
last para.
That is Purushottam Sethi Nodal High School.
From Purushottam, then since
Purushottam Sethi Nodal High School, Govindpur, in the district of Bhadrak.
Sorry, school so and so to any other school.
No, Bethnati Girls High School.
No,
yes, any other school. Any other school.
Any other government high schools.
I have indicated that one vacancy is there in that particular school.
And preferably to
Bethnati Girls High School.
Bethnati Girls High School.
Bethnati in the district of Mayurvanj.
Bethnati Girls High School.
Yes.
At Bethnati, where vacancy is presently availing.
You also may indicate that in the district of Mayurvanj.
In the district of
Mayurvanj.
Right, that name. Mayurvanj. First off. Learned counsel for the petitioner submits that his client has given health reason of his spouse, and he having a clean track record, the subject representation ought to have been considered favorably. First off, this having not been done, he submits, interference of writ court is eminently warranted. First off. Next, learned AGA, having some time resisted the petition, now fairly agrees with the suggestion of this court that the subject representation of the petitioner should meet its fate at the hands of OP number two. OP number 2 in a time-bound way and in accordance with law. First off. However, he caveats that all contentions of the plea should be kept open so that a meritorious decision would be taken on the said representation by the jurisdictional authority. First, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for taking the decision on the subject representation and also of informing the decision taken to the petitioner in writing. But all contentions are kept open. Next paragraph. Since petitioner has pleaded his spouse's ill health, it is open to the OP number 2 to solicit any medical opinion from the concerned quarters if need be. And in that connection, petitioner shall cooperate. Petitioner shall cooperate. Okay.
Item 27.
Passover, my lord.
Passover. What is this matter about?
This is for transfer.
Matter, my lord.
This is for transfer on the ground of health, but where he is staying, it is same, he is requesting for the same distance place. It is nothing advantageous.
Why not that is a teacher?
Yes.
Teacher. You want to contest in election in that school or what?
No, my lord.
Same distance, 40 kilometers.
No, my lord. Not same distance.
My lord, it will be around
60 kilometers ago.
16 kilometers. It will be 20 kilometers. Godi say.
60 kilometers.
Maximum it
Google and ask how many kilometers. Take out your phone. It will depend upon you now. How many kilometers?
It is near about 40 to 45.
Go to Google and see.
I have checked up.
You have checked it now. Is it true? No.
Godi say it is.
Google in the road, it is near about 40 to 45 in between. Google directly it is giving the
From Cuttack end, it will be maximum 15 kilometers.
No.
Maximum.
Godi
say
the same name, 2 places there. But whatever
Which place to which place? Not whatever. Distance is also a factor.
Case 10, he has transferred to Bilipada Primary School, Kontapada.
Now you are working at Godisai and requesting to transfer for Vidyabathurpur. Annexure page 24.
He was transferred from Godisai. Transferred from Godisai, Kontapada.
25/7 you are transferred.
Yes, 25/7. Against that, I have already made a representation to the director. Your lordship may see.
Director has to take a decision.
Take a decision.
To take a decision and tell him go there.
Till then, no portioners.
The short grievance of the petitioner is as to non-consideration of his representation dated.
Representation dated
13/8, my lord.
13/8/2025.
And mode of communication is also
wherein he has sought for
not there.
His retention at the same place.
Same place or nearby school?
Or posting to a nearby place by modifying the transfer order dated 25/7/2025. First off. Learned counsel for the AGA appearing for the respondent, in all fairness, agrees with the suggestion of this court to instruct OP number?
OP number
2, my lord, director.
OP number 2.
To take a call on the subject representation if all contentions are kept open. First up, with this proposal, petitioner's counsel is agreed. Next one, in view of the above, petition is disposed of. Fixing a period of petition is disposed of. First up, petitioner shall be. Have you been relieved now?
They have said dim relief, but nobody has joined in my place. I am still there.
You take decision tomorrow and send wherever you want to on this petition. I will not fix any time. But till then, you continue him there only.
Provided, my lord, sometimes somebody will come and...
No, provided nobody has joined there.
That should be there.
Till a decision is taken on the subject representation, petitioner shall be continued in the same place. If already some other candidate has not filled the vacancy. All contentions. Yes.
Item 28. Well, this is third round of litigation. Here I have challenged the rejection order dated 2/7/2025 under Annexure 8.
Rejection of what?
Well, rejection. Well, all urban local body schools were taken over by the School and Mass Education Department way back in the year 2004 by the state government by passing a resolution dated 28/2/2004. Although our school fulfilled all the eligibility conditions, because of lack of communication by the urban local bodies and the School and Mass Education Department, our school was left out. Thereafter, these two petitioners approached this Hon'Ble Court way back in the year 2009. Direction was issued to consider taking over our schools under the School and Mass Education Department.
No, where is that taking over resolution?
Resolution, my lord, that is under Annexure 1. The first resolution.
Any right in favor of the school?
My lord, you also may kindly...
Prerogative of the state government to...
No, my lord. Here you also may kindly see Annexure 3 at page 23. My lord, en masse, all the schools...
No, where is that?
All the schools under urban local bodies, those schools were transferred to the School and Mass Education Department, and the concerned employees were declared as government servants with effect from 28 February 2024. My lord, may kindly see the subject. Transfer of the left out primary schools of 6 urban local bodies, lower secondary and secondary schools of urban local bodies to the school. Yes. My lord, although we fulfilled all the conditions, our schools were not taken over because of the, my lord, communication gap.
You take notice.
None.
He accepts notice. Yes.
Item 30.
May I please?
This matter relates to the placement of the lecturer, to the petitioner to the post of lecturer group A scale and the return. This already your lordship has passed the order in
Loknath Behera.
My lord. So I feel that I have filed repentation. My repentation may be considered on Annexure 7. My
Petitioner has structured his prayer as that done. Next one. Learned counsel for the petitioner, drawing attention of the court to his client's representation dated
14/8/2000.
2025. Submits that his client would be satisfied if a direction is given to consider the said representation in a time-bound way, keeping in view the law declared by this court in Loknath Behera versus State of Odisha,
In WPC
number 2062 of
124.
Now see where you have stamped that, how we should read.
Well,
You have put the stamp, affixed the stamp on that prayer column itself. You mean your office?
prayer column, well, there is my love. In prayer
No,
column.
I am not able to read because the stamps are affixed there. So that judge should not read everything.
I'm sorry.
Would be stamp.
I'm sorry.
Okay.
Annexure 7.
2062 of 2024. A copy of the judgment avails at Annexure 7. First one. Next paragraph.
7 is representation.
Yes.
Yes.
Learned AGA very fairly agrees that the subject representation should meet its fate at the hands of OP number
1.
OP number 1. And he would ensure that would happen. First time, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of. Time for compliance is 8 weeks, which would include communicating the decision taken on the subject representation to the petitioner. First off, it is open to solicit any information. That's what. All contentions kept open. No, the copy to be acted upon. No course. Yeah.
Item 31.
Yes.
Item 31.
What is the 29/4/24 order, Mr.
My lords, earlier he had approached this honorable court. And there was a direction to consider his representation.
Unutilized leave salary.
My lords.
You take notice and file a emergent notice. AGA on request accepts the notice for OPs. Any private party? Go to cost statement. No, you only will appear perhaps. Dhaneshwara High School.
My lords.
Emergent notice to OP number 4. Okay. 1, 2, 3. Yes, next.
Item 32.
May it please your lordship.
Yes, sir.
When the petitioner is an assistant professor in economics, Utkal University, Bhubaneswar, is aggrieved by the illegal suspension order continuing since last 1 year without any review.
5 years.
1 year, madam.
1 year.
Yes.
Which is that apex court decision which said the decision has to be taken within three months, not whether to continue or not.
Ajay Chaudhary, madam.
Ajay Chaudhary.
Yes,
ma'am.
But no review has been done for the last 1 year.
Did you ask them to rescind your suspension?
Yes, I have submitted representation, my lord.
Where is that representation?
And apart from that, my lord.
No, you first answer the question.
Yes, ma'am.
Then you can jump to other tree.
Lordship.
Yeah. Suspension is 18/9/24.
My lord.
Why brother, 18/9?
My lords, this is university.
Emergent notice. Who appears for Utkal University?
Mr. Dayanand Mahapatra, senior.
AGA for
OP1.
OP1. Why how government is concerned with your suspension? With the university.
Formal. Higher Education Secretary.
President of India also formal part. Notice to OP number 1 is dispensed with, since it has nothing to do with the cause in question. First of all, issue emergent notice to OP number
2, 3, and 4.
2. Okay, to university. First off, in addition to taking usual steps, petitioner is permitted to serve copy of the petition on counsel usually appearing for the university. First off, call this matter of immediately after service. Yes, you serve and move a memo on will take up this matter.
Lordship, may I pray? Can it be taken up any date next week, my lord? I'll serve the copy today only.
You serve and ask that panel counsel which date he wants, so that we can put that afterwards. Put a date.
May I intimate after lunch?
You inform our court officer.
After lunch, my lord.
Okay. They cannot be continued endlessly that way. Because we will be paying the subsistence allowance without work.
May I submit one thing, my lord, if your lordship permits?
Yeah.
The inquiry committee have recommended punishment against the petitioner. Not punishment, they have recommended certain actions. The ICC proceedings is pending, but they have initiated departmental proceeding in the meantime.
Let us see. You serve copy, my lord.
Wait, please, Your Lordship.
Yes.
Your Lordship, the petitioner challenges his transfer order that is under Annexure 1, page 15, Your Lordship, friends.
Dated?
Dated, Your Lordship, 16th August 2025.
16/8/25.
Lordship. Lordship, may I kindly see that Annexure 1, page 15, Your Lordship.
From which place to which place?
Your Lordship, from Rasgopurapur to Vaidyanath, that is under the district of Marwan.
How many kilometers?
190 kilometers, Your Lordship.
How many years you have put in service?
Your Lordship, I am working here since 2006.
2006?
Lordship. And I am the lone mathematics teacher for class 9 and 10 students.
Any other person is posted to your place?
No, Your Lordship, no one.
Why, brother?
This is my lord's MLA recommendation.
Then we will stay there. MLA has no business to do all this. Issue emergent notice. The GA is requested to accept notice for the OPs. Government counsel for the petitioner presses into service. Various interim orders granted in various WPs involving substantially matchable fact matrix, and therefore his client also should be extended the same benefit. First off, there is a prima facie case made out. First off, next paragraph. In the above circumstances, there shall be stay of the impugned order of transfer so far as the petitioner is concerned, and petitioner shall be continued in the same place wherein although he was working before the issuance of the impugned order of transfer. First one, call this matter along with the WP number, so and so and so. Okay.
Objection.
Okay.
Item 34.
May I please, Your Lordship?
Yes, sir.
Page 13 of the writ petition, my lords, is a document which shows that I am an enlisted contractor under the Orissa Construction Corporation Limited, which is a government of Orissa undertaking. Now, Your Lordship takes that document just at the bottom of the table.
Page number?
Page number 13, 1-3.
Go to 1-3.
1-3. I'm a
bottom you say.
Just below the table, Your Lordship sees finds enlistment valid up to 7/9/2024.
7/9/24.
24. So before this period elapsed, my lords, I applied for renewal. And if Your Lordship takes page 16.
Renewal you applied on?
I applied before that date.
26/9/2020.
I applied
on 26/9?
2024. No.
Cannot be.
No. It was before that date. Regarding your application.
This is the date.
Application. They have responded to that application on 23/9/24 at page 16. Page 16, my lords.
Yes. That is 23/9.
That is 23/9, where they say, with reference to application submitted for renewal, it is
dealing with your provisional renewal would stand cancelled. Provisional renewal was granted to you.
Yes.
And that was subject to condition. You can, whether you complied with the condition.
Everything complied. I completed that period as a contractor under the OCC. I executed some work also.
Take notice.
The difficulty is, my lords, which I have stated, Annexure 5, there is a tender which has been floated in the meantime. I am unable to participate in this tender. Your Lordship may just stay the process of this tender till they respond to my...
No. That will cause enormous injustice to the public interest. These are not the public tenders.
Point of delaying the final till Your Lordship adjudicates, because if I am out of this tender, if I do not Participate
You also participate, I'll permit you.
Yes.
In the meanwhile, let them not.
Yes. That will suffice.
You participate.
Your Lordship may indicate that.
Issue emergent notice.
I have received notice yesterday by mail. Then we have the corporation.
Have you filed the caveat?
Madam?
Have you entered caveat?
No.
Then you cannot enter the fray till I issue notice.
They just emailed me yesterday.
That's all right. The rule requiring service is one thing. Entering caveat is another. There is a caveat provision. If you wanted to oppose any prayer, you should have entered the caveat.
No, they served me.
That is no caveat.
Okay.
They are going to serve because the rule requires that. It is only to alert you so that you can file the caveat. Yes. Heard learned senior advocate appearing for the counsel on record for the petitioner. First off, he drew attention of the court to the response of the General Manager Civil of Orissa Construction Corporation Limited at Annexure 44,
Annexure 4,
dated 23/9/2024, wherein provision of renewal is indicated subject to petitioner complying with the condition of making payment of 11,800. So he tells the court that this payment is already made.
It's there. The document is there at the next page.
As reflected in Annexure.
Annexure 4, I have complied with
4 series. Annexure 4 series. And therefore, he seeks a stay of the tender process now floated wide Annexure
5.
Annexure 5. First off, having heard the counsel, the senior counsel, and having the prima facie perused the petition papers, this court is of the considered opinion that staying of entire tender process is not warranted, keeping in view the higher interest of the public at large and justice of the case at this stage be met by permitting the petitioner to participate in the tender fray subject to usual compliances. First off, which respondent?
That is respondent
OP number?
1.
OP number 1 is directed to permit the petitioner's participation accordingly, subject to outcome of the petition. Is very much urgent.
Urgent copy of your lordship.
We'll make next order. You must let order immediately so that we will copy to be acted upon. Yes. Let my name be so. Shushan Kumar issue notice and see so it's all terms of this.
I mean, pardon me, sir.
Yes, sir.
Item 36 for order of mirror.
36, sir.
36. I am filing memo for withdrawal mirror because there is no cause of action survives. The interim application was filed for extension of time. Your lordship directed to make payment to the government within 1 month.
You have made that?
Yes, we have already paid. So,
Lieutenant counsel for the petitioner submits that the petition has become infectious on the happening of certain developments and therefore it be accordingly disposed of. First off, AGA for a respondent, who appears for opponent?
Government will.
Mr. AGA, do you have objection for?
No.
Lieutenant AGA does not dispute this position. First off, next paragraph. In view of the above, petition is disposed of as having become infectious.
I may be person, my lord. Item 57.
The senior advocate is in this matter only.
Yes.
There you actually already passed an interim order.
Staying that payment of
payment of
300 crores or something like that.
Oblige.
Yes.
40 crores.
40 crores.
So
Your Lordship directed them to file the counter.
I did not direct. I permitted him to file the counter if they wanted to. Yes, what do you say?
My lords, will file counter another 2 weeks' time may be given.
Lordnet AGA seeks 2 weeks to file counter. First off, do you have objections, sir, for filing?
No.
Lordnet senior advocate appearing for the petitioner fairly agrees for granting the said time accommodation, subject to the condition that the interim order be continued. First off, there is force in this submission. Next paragraph. In view of the above, the interim order is continued till next date of hearing and call this matter after 3 weeks.
Pardon to mention, Lordship.
Yeah.
Also, item number 35.
35.
It's a connected matter, Lordship. Previous 25 batch of students so already approached this Hon'Ble Court. The court has ordered for the notice. So we request to match our matter also in that list.
That matter, issue emergent notice. Who, AGA?
It's a Union of India.
It is we are appearing, my lord. We are appearing for item 35. But Kendriya Vidyalaya have a different panel of counsels to only for 1 and 6.
You appear for 1 and 6.
1 and 6. The ITEP school is there. ITEP is under us. And the Union of India. Kendriya Vidyalaya is a different panel, my lord.
Shri. So appears for.
My lord, I am for 2 only.
OP numbers 1 and 5.
1 and 6. We are for 1 and 6, my lord.
DGA accepts notice for OP2. Other respondents?
Kendriya Vidyalaya, Lordship may issue notice.
Issue notice to the rest. Emergency notice to the rest. Call this matter along with WP number. Give that number. Give that WP number.
Item 59, my lord. This is matter relating to.
Wait for 10 minutes, sir. Just 10 minutes.
Item 59, my lord. This matter relating to block grant employee pension matter, my lord. Similar, my lord. This similar matter last reported 3rd week of September, my lord.
It is other matters are
59, 60, 61.
That is from September.
59,
60, 61.
60, 61.
My lord.
Call this matter 3rd week of September.
In this case,
connected matters.
Number is there, my lord. Wrongly. 2017 of 2025, my lord. Wrongly.
Yes, write down na.
20017.
20017
of 25.
Of 2025.
Pardon, my lord. Item number 39. There is a little bit of correction.
39.
Only, yes.
2015 matter.
2025
Last time actually, I am appealing to the opposite party number 2. There actually last time they took adjournment, you know, to fix it to bring for further discussion.
39 all of them.
Your Lordship, I am there in item number 39, Your Lordship.
Which is your matter? Which matter you want to mention?
37. She is mentioning 37.
37. Sorry, ma'am. I am extremely sorry.
No issue.
There is a simple correction in place of there is an typographical error. So
what is that?
In place of opposite party number 1 and 4, it should be 1 and 2 only. If directly.
Learned Counsel Srimati Patak submits that orally applies for the leave to correct the prayer column.
No.
Cast title.
Order, previous order.
Previous order.
Yes,
made by
instead of opposite party number 1 and 2, there was a order to OP number 1 and 4. There is no 1 and 4. Only opposite party number 1 and 2.
Learned Counsel appearing for the petitioner points out the mistake committed by this court that it mentions in its order dated 28/7/2025, interim order dated 28/7/2025, opposite party numbers 1 to 4, when there is only one opposite party.
1 and 2.
1 and 2.
Yes.
When there are only OP numbers 1 and 2. And therefore the same requires to be rectified. First up.
I will submit the requisites tomorrow. And postal requisites.
The same is rectified. Text be to justiciate. Justiciate. All right.
38 minutes. Orders.
Then we were saying something further when I was dictating. I do not like people.
Notice and the postal requisites will be submitted tomorrow, man. I'll submit tomorrow.
Requisites to be submitted accordingly. And if permission to be processed by the registry.
Much obliged.
38 minutes. Orders matter.
38
minutes.
2025 matter.
Minute. That is a block grant pension matter. Let it come up third week. I will file the requisite to opposite band number 3 by tomorrow. And the tag matter is 20017 of 25. That has been instead of 15 minutes, it will be 25. 20017 of 2025. Requisite is by
all right. Requisite tomorrow furnished within 3 working days.
Minute.
Okay.
Let it come.
With respect of whom? Requisite
OP number 3.
OP number. All right. All right. Any short matter within any mentioning? Nothing?
Your Lordship, item 40, I'm praying for a short adjournment. It may come any day after 9th of next week. We are actually badly placed till 9th. So it may come any day after 9th next week. Praying for a short adjournment.
2018 matter?
Yes, Your Lordship.
This matter after 2 weeks. 3 weeks, so that it will come in the second week of October. Very good. On request of your
I'm for the petitioner in the first matter and the opposite party number 4 in the second matter.
Okay.
May I please, Your Lordship? I am for petitioner in item number 39, my lord.
Item number 39.
Yes, my lord. My lord, last occasion I took time to take the instructions regarding that, my lord. That whether the case has been filed or not in the lower court, my lord. Because the lady is very medically unfit to come to the office, we couldn't obtain it meanwhile, my lord. My lord, I need further 1 week of time.
We'll hear that afterwards. Come afterwards.
May I permit to mention, my lord, one matter. Item 55, that is the admission into other Vidyalaya. Student now academic session is already started. Honorable, this matter was before the Honorable Chief Justice Court. And the Honorable Chief Justice also, only your lordship, see only 8 number, only one moment. This will be taken up urgently, either today or tomorrow on the top of the list.
No, it is not posted today.
Posted today, 55. I anticipate may not reach. That's why tomorrow the top of the list can be disposed of. Only one point there is nothing. One seat kept reserved. So only that may be taken up either before rising or tomorrow in the top of the list.
Let it come in the list. You just mentioned in the morning. You mentioned it.
Today's list.
Yeah, we'll take up
item 55.
All right, now you argue.
Now, yes, my lord.
Huh?
I can argue.
It is already there, no? I was
Yes, madam.
it is not yet said.
Yes,
Yes, argue.
Yes,
Because the
madam.
student's fate is involved.
yes.
Yes.
This is the applicant is the only the ward of the Adarsha Vidyalaya employee. The applicant is Samanita Rao is the ward of the Adarsha Vidyalaya employee, and she seeks a reservation there because there is a provision that is and the guideline 5 Romans.
Yeah, we is covered by judgment, no?
And 6.
Yes, my lord.
On what ground they have denied
One
admission?
seat also kept reserved.
No, on what ground? They have denied admission.
Denied admission, but they only the honorable single judge they directed to to look into the matter. Only they did not touch the reservation category. They talk only they told that she has obtained the interview in the mark 38 below mark. That she cannot be considered. But the reservation category, the word of the employee of the other Vidyalaya, she is only seeking the reservation category. And there is a seat also kept reserved for her. And now the Honorable Chief Justice, that is the already adjudicated matter, because since the single judge matter pending before the Honorable Court, directed to dispose of this.
That I have seen. Question you are not answering.
Yes.
You are entitled to reservation is one thing.
Yes.
Where is the entitlement to concession in the percentage? There are two different things.
Yes, two different things. But only if the word of the employee is only wants to take admission, then the collector has to recommend her name for consideration and only reservation category. And she also has to appear in the interview. She also got the mark, sufficient mark.
How many marks?
38 marks. 38 marks.
It is less than 40.
Mind 38 marks not in the disabilities categories, but only 38 marks in the selection, there is a procedure interview. Only below her, other have been also selected and taken admission in other ground. But now she should be considered on the ground of only reservation category.
We have understood that.
Yes.
What your argument can be understood even by first year law student.
Yes.
But you are not answering my point. Reservation is one thing. Reservation is of seats. Others cannot be given there.
Yes.
Provided you comply with the required minimum.
Yes, we have complied. I have complied.
You have complied that one?
Yes.
But cutoff is what, how much?
The cutoff, there is no cutoff mark here. There is no cutoff mark. Your Lordship,
yes, brother. What
yes,
is
madam.
it?
Lordship, I am indulging my lord's attention, my lord, so far the guideline is concerned, my lord. Page 24 of the read petition, my lord. My lord, the regulation 5, Roman 11, my lord.
5:11.
Page 24, my lord.
5%.
5% sanction seat
reserved for the children of the employee. That's all right.
Yes, my lord. But then, my lord, then 12, my lord. Preference will be given in admission to the wards of the employee of Orissa Adarsh Vidyalaya Sangathan on priority basis. They have to appear entrance tests as they will be selected against the post earmarked for the respective category, my lord. Then, I am indulging my lord's attention, my lord, to my counter, my lord. I have filed the reply, my lord. The Lordship will say internal page 2 of my counter, my lord. Paragraph 7. What mark he secured, my lord? We are not denying it. I'm coming on.
Come to the well of the court.
My lord. Para 7.
Come to the guideline.
Let me complete. My lord, that para 7, my lord, that it is humbly submitted that the petitioner has secured 38 marks.
Where?
In the Odisha. Para 7 of my counter, page 2. Internal counter by my lord, OP number 1 and 2. But I am filing the original. We have filing email yesterday.
You received the counter. You give share one copy.
I have already
Call
come.
tomorrow. Let him look it.
Yesterday I have short mail. He received in token mail.
He has received.
Yes, madam.
I have not received, but someone I do not know my associate may receive.
Okay.
I have to.
Call it. We will have it tomorrow.
Tomorrow. Top of the list.
No top of the list. It will come. We can mention.
Yes, sir.
There is nothing like top because I cannot alter the Twitter program.
Mine. Okay. Mine.
Call tomorrow at the request of. Why that is not uploaded? Yes, so just
Yesterday we have Yesterday we have filed.
Okay.
Yes, your lordship's kind permission. Item 32 for litigation of debt, my lord. I have contacted my learned senior who is appearing for the university. Any date with the
any date will do. So you are appearing for the
senior corporate, Mr. Ganaranjan Mahapatra will appear. May record his name, but he let him serve a copy. I will take instruction. Can it be taken off, my lords? Any day convenient, my lords, after 20. So we commencing 22nd, my lord? In between, my lords, will take.
23rd? Will it be delayed? That suspension matter, no, Ajay Chaudhary.
After that, they have initiated departmental proceeding during pendency of the internal inquiry matter. So that is illegal. And I felt that I have got that stay of that proceeding. Till next date, my lordship may kindly consider.
No question. Merely because without the preliminary inquiry is not a precondition for holding inquiry is the Supreme Court decision, latest decision. That goes against it. So far as revoking of suspension order is concerned, there is arguable case.
The rule says
because of Ajay Chaudhary.
The UGC rules states that the inquiry has to be completed, chance of appeal has to be afforded. After that, the proceeding can be initiated. All these things are pending, man.
Let us see call this matter.
Tomorrow, lordship may kindly call. I'll try to respond.
I will take instruction. We have to take instruction from the university. It's not particularly possible.
So we'll call this matter on 17th.
Well, so it will be better, matters if minors will take it up. Suspension is there. Week matters more. Matters 22nd week commencing 22nd any date matters.
But in the meanwhile, do not trouble him.
Called for
the Department of Proceeding matters. They initiated the proceeding. Probably I don't know what is the stage.
No, he is saying in terms of the rule.
Yes,
Supreme Court said in the absence of the rule.
Yes.
Preliminary inquiry is not a must.
Yes.
Where rule prescribes preliminary inquiry.
I understood matters.
Then he has an arguable case.
Yes, I understood matters. I don't dispute now in that particular context because I have not gone through the detail. Only I request that if he solves a copy, I have to send the copy to the university and then to take instruction.
But then till then don't precipitate the
yes,
that is matters. Preliminary one inquiry matters is a stage only.
Shri
Ganaranjan Mahapatra
issue notice, emergency notice. So it's all right. His name is mentioned for the minutes. Mahapatra, the panel counsel, on request appears for the OP University. First, next paragraph. Learned counsel for the petitioner submits that in terms of UGC regulation, which regulation?
Regulation Annexure 22, Annexure 21, page 58.
Regulation name. UGC has got a set of regulations.
Yes, that is UGC, Prevention, Prohibition and Redressal of Sexual Harassment.
Annexure?
Annexure 21, madam.
Annexure 21 regulation.
2015.
Comma. Till the preliminary inquiry is accomplished, comma, no coercive proceeding can be commenced against employees like the petitioner. First up, there is some force in this submission at this stage. First up, next paragraph. In the above circumstances, the application supported by IA number so supported by affidavit is favored, and the university is directed not to precipitate the matter pursuant to
Annexure 19.
Annexure 19 till next date of hearing. Call this matter on 24th. Well,
name Mr. Maybe reflected in the cost title. So
your name also?
Well, no, well, sir.
Mahapatra's name, na? Yes. Yes.
Item 39.
May I please, Your Lordship? I am on BC, my lord.
Yes.
Yes, Your Lordship. Lordship, the thing regarding Your Lordship has previously asked me out whether there is a civil case is pending or not because of the plaintiff, the petitioner herself is more than 70 years now. We couldn't obtain the instructions, my lord, as asked by Your Lordship. And Your Lordship, if the case was been filed, it would have been with us, but in our records, we couldn't find it. So regarding that,
page 4, let's you kindly see the writ petition.
What is this matter?
I'll submit there. Page 4, let's you kindly see.
4.
Paragraph 9.
CS 110 of 2005.
Petitioner also served advocate's notice on 10/3/2005 to the opposite party number 1. The petitioner has also moved the civil court by filing CS number.
That 10/3/2005 section 80 notice.
That's what is mentioned here.
Not forthcoming. Anyway, next.
So this is yes, actually I am the allottee in fact. The adjoining landowner, I purchased the same by register said it. Development authority is the authority actually of the land. They have allotted to my vendor. My vendor allotted in my favor. There was a small strip of land, which is the end of the plot, that was not allotted to anybody else, which cannot be allotted to except the adjoining owner, as per their norm. So it was applied and it has been allotted. They demolished everything that illegal construction, handed over my possession. I fenced it. I brought it within my compound. And thereafter, suddenly they trespassed into the land. And now 144 application filed and all that. The suit still pending. Now they have filed a writ. Interim order is there.
Your Lordship, because this matter was filed during the 2015, my lord, because these allegations are very wrong, my lord, because the civil suit is filed there, but I agree because that is also written in the writ petition. But regarding that, we do not have any kind of instruction whether it is pending or not.
No, it's your suit. You can.
Yes, my lord. Yes, my lord, I agree. But because of when we contacted them, they couldn't give us the information regarding that, my lord.
Now
you have filed the suit. You work out your remedy there.
Yes, yes, my lord. I understand your lordship's what your lordship is saying, but I need further 1 week because when we wanted to know whether the suit is pending or not, they couldn't contact us back, my lord.
Assuming the suit is dismissed, still will not, because you can challenge the decree in appeal.
Your lordship, I do not have such instructions because this matter was primarily addressed by Mr. Late Ashok Kumar Mahapatra, my lord. So I need some time to gather the informations regarding that.
2015, last time also you took time.
Yes, my lord. Yes, my lord. I have taken the time, my lord.
Last time also you have taken time. How many times?
Yes, my lord. Only 1 week will suffice, my lord.
Huh?
Only 1 week will further time will suffice, my lord.
Next week, Mr. Sir will take up. My daughter is saying tomorrow. His senior should not. Yes, call this matter. Next Thursday. Fix that date. Finally, at the request of. Finally and reluctantly.
Next Thursday.
Yes.
Grateful, your lordship.
11th.
Yes, your lordship.
11.
In that suit, what they have prayed, do you have the copies?
No, sir. I don't have the copy, but my instruction is the declaration.
Declaration. The writ is not maintainable on suit is filed. Anyway, okay.
They are also short for that was refused and
interim order to continue until next date of hearing.
Yes, much obliged, my lord.
Item 41.
Your Lordship may indicate it will be taken up on that.
It is posted only for that purpose. Item 41.
May I please, Your Lordship? Third question involves this question, Your Lordship. That is, in service matter, persons similarly placed should be treated equally, similarly.
Why in service matter? In all matters.
My Lord, that is, Your Lordship. In this case, this present petitioner was working as a daily wager in Utkal University, Bani Bihar. After so many years of service, when his services were not regularized, Lordship, kindly see Annexure 1 is the gradation seniority list of all the daily wagers. That is,
for my lord, my honorable brother, begins my lord, may I submit only one thing. Number of cases are there. My lord, there is a direction to club up all the cases to get it hard, my lord, at once. Means we are giving the copy of that.
2018 matter. How many cases are?
Number of cases, my lord. So I think to me, my lord, to my knowledge, my lord, it will be more than 8.
Not all this matter.
After item 46 today,
we will have this matter. 18 matter. 7 years are over. How long these people should wait?
No, they have been regularized. They say they should be given benefit on
retrospective.
My lord, that is and also
it's not that they have,
that is the judgment, Your Lordship, I have given.
We'll go to that. Man, thing is that today is also item number 46.
All right. 46.
But also same matter.
We called along with this
so that
matter.
Whatever decision, man, it will be for all.
When Tuesday?
Tuesday, man.
Any difficulty?
Tuesday.
You are half-hearted. Therefore, I am asking you.
Sorry, mercy, it is 9th. Mercy, can it be taken on 10th?
All right. 10th. Don't. They should know whether they will, their fate they should know in the court.
Yeah.
My lord, we can't keep matters payments wrote with seeing your educational appellate tribunal at Bhubaneswar.
Yes.
2014 matter.
Education tribunal. Yes.
Educational tribunal. 11 years. What is that? Is it Keshavananda Bharati? Whether he is entitled to grant of aid or not, termination is good or bad, suspension to be revoked, whether disciplinary proceedings are properly held, promotion is rightly withheld.
Most of those cases also depends upon the records also. Not there is no necessity of oral evidence.
So it's all. Item 42. But people are very tolerant. People in this state are very tolerant. They are tolerating judges like me and the
that's the exception.
This is too much actually. Yes.
My lord, petitioner's joining letter has not been accepted by OP number 2. Only reason, only ground is the delay.
OP number 2. Which matter?
Service matter, man, appointment.
No, which is service serial number?
Yes. Appointment letter. Annex. My lord, kindly see the earlier order dated 1/80/2025. Lordship directed to ascertain
whether vacancy is still available or not. I said no.
Yes, ma'am.
I remember. Yes, Mr. H.
No, Lord.
There is some delay. 1 month order.
2 months.
2 months. 2 months delay. Why delay?
No, my lord, it's not 2 months.
2 months, 29 days.
3 months.
2 months, 29 days.
So it is 29 days, therefore not 3 months.
No, not 3 months. My lord, a government notification clear indicated 6 months is requirement. Annexure 7 is page 80 is government notification clear indicating that a 6 months is 6 months government can extend.
Rule says
yes, rule
after 30 days it will be elapsed because it's not communicated anything that for extension I am ill, something. Nothing is there on record, my lords. Otherwise, he was selected.
Read that rule, whether rule requires any application or communication from your side, or government can do it on its own.
Page 18 annex.
What is your explanation? Why you did not join for 3 months?
Only, my lord, illness, serious illness.
What illness?
My lord. Annexure 5P, page 15 is the medical certificate.
Yes.
Suffer illness from 24/7/22.
What is that illness? It is as bald as your argument. Illness comes to everybody. Innumerable causes are there. What is that illness called as?
Fever of unknown reason. Paper of unknown origin.
For 3 months, 84 days.
Sorry, 24/7/22 to 16/10/2022.
That is 84 days.
84 days.
What is that illness for 3 months? Which illness will last for 3 months? There are illness which you have to live throughout life is another thing. But what is that illness? Medical certificate should show, unless there is some confidentiality, etc. But this is not one such thing. What was the illness?
FUO. See, given below suffering from FUO.
Everybody suffers illness and life both, but point is, what is that illness? Which prevented you from even telephoning them or shooting a letter saying, sir, I am not well. I will not be able to come and report for duty.
Madam, during that period, he is bedridden.
Where is that? No representation given. No representation given. Where is that rule? How rule reads?
My lords, Annexure 7.
Annexure 7.
Representation is given?
No, my lords.
Yes, madam.
After 30 days.
After 30, not 29 days. Repetition 17/10/2022.
After revalidation of the appointment order.
My lords, Annexure 7. Office memorandum dated 20th September 2019, para 1. In the offer of appointment, it shall be mandatory to indicate that the offer of appointment will lapse if the candidate doesn't join within a period not exceeding 30 days. He was given 15 days. My lords, he was selected. Nothing malafide against him. But for a long period, he did not inform even the authorities that he has any problems. That is why it was lapsed.
No, order of appointment will lapse after 6 months. Not on he not joining.
My lord, 6 months, within 6 months, the authorities have power to extend the date of appointment. No, provided
cause is shown. Yes. That I understood. But come to the text of Rule 3. What is this? Is it a rule?
This is
the office memorandum. You are interpreting it as if it is a parliamentary statute.
No.
It is office memorandum. It is for the benefit of those people only.
Guidelines.
It's a guideline. That's all. It only guides. Kindly come to para 3.
My lords, if even after extensions, if any granted by the competent authority, a candidate doesn't join within the extended time, we shall not exceed 6 months.
Correct.
My lords, here is a case.
Read fully.
My lord, the order of appointment will lapse automatically after
expiry of 6 months from the date of issue of the original order of appointment.
Formal order.
A formal order to that effect shall be issued. Any order is issued saying that he having not joined the consent appointment order stands rescinded.
My lords, what Hon'Ble submit, it is not a case extension of time was given beyond the time prescribed in the appointment letter, my lords. Appointment letter, your lordship kindly see, he was given time 15 days time.
Correct. 15 days. But who will say no to the job offer? Most of the cases who come before us are where we are not being given the job. Unless there is.
My lords, I understand. He was selected. He is entitled to that. But for his lapse, he is suffering enough.
Yes, sure. See, sometimes there is a medical certificate. There is one rule in I think in Medical Council Act or some which says certificates issued by the competent doctors must be acted upon.
No, my lord.
There is such a law. Section itself says that.
My lords, the disease should be so acute that
prevent him from writing a letter also.
Making a rate. That is not there.
No, it's all right. Did you ascertain that whether any vacancy is filled up?
My lords, that instruction we have written a letter but not received.
No, they have not received your letter, or you have not received their reply?
We have not received the reply. It is sent on only on 19. My lords.
On 21/8 we had directed.
180.25. 180.25.
1/8/25. They have, you have made delay in joining, and now they have made delay in sending the letter, taking cue from you.
My lords, in fact, pursuant to letter dated, order dated 21st August 2025, this
they have sent a reply.
This letter was sent. Before that, the Lords will grant 1 week time. 2 weeks time.
My lord, 2 years, 6 months has been lapsed already.
It's all right. Matter is before this court, na?
Before this court.
Yeah. You did not do any haste when in joining the duty nowadays. And now you say take up this matter. Nothing will happen. Wait. Call this matter on 15. Yes. At the request of the GA, who in the meanwhile shall assert whether the vacancy in question is filled up. Yes.
Item 43.
Item 43. My lords, item 43, in fact, it requires amendment because the earlier this was under the Department of Revenue, my lords. In the meantime, it has been transferred to Mines, Department of Mines. Yeah. So all the records were sent to the concerned mining officers. His claim is money claim towards some work done by him. So now it has to be dealt with by the mining official.
Yes, sir. I have made then parties also. Mining officer has been made other parties. And
mining officer or secretary to the Department of Mining. Any monetary claim is involved.
Yes, yes.
Then a secretary to the mining department.
No, mining officer is also a party, my lord.
What that officer will do?
Officer of the record has been transferred to mining officer.
Mining officer or
mining officer? Mining officer is a party to this case.
Correct.
And he is the government is the government council is the authority has the power to take.
Unless you make
the government at all a party.
I have mining officer is a party.
Mining officer is not government.
Not government.
Money to be paid. But Supreme Court said in one matter, in a mining matter, where claim is to the money, which the government has to pay. It pays it from the exchequer.
My lord, what happened, my lord?
Instead of wasting your time, I will permit you to implement the Department of Government of Orissa, Department of Mining, represented by Secretary.
That I can do, my lord.
Yes.
Initially, the revenue officer, Tahsildar, has collected the money from the successful bidders and with a endorsement that amount will be paid to the petitioner. That
But they did not do that. You will also kindly come to page number 7, annexure 1.
Page 7.
Page 7, annexure 1. Last paragraph. Therefore, it is requested to furnish the documents for filing of EC in all respects to the undersigned at the earliest, and the cost of preparation of the required documents for EC of 16 number of solid sources 14 will be reimbursed from the successful bidders after completion of auction procedure and will be deposited to your SBI account.
The Tahsildar himself said that.
Yes, Tahsildar has given that, and I, as per the letter, I submitted the documentation with my bills. That is in the year 2020. By then, Tahsildar has collected the money from the successful bidders.
How much money is paid?
Money is, I have given the bill, that is annexure 2, page number 9. 7,50,000.
You did not go and do something more there.
There are 21 number of sources.
My lord's partial payment was made.
No,
how much?
Not a single.
Show that.
My lords.
Where is your objection?
They have not given the counter.
No objection. Counter is not filed.
My lords, not filed, but
you will follow the petition.
Tahsildar, my lords, only see the given instruction that he has transferred all the documents to the mining department.
No, that is not equivalent to the assurance, discharging of assurance. You said that after that auction purchaser makes the payment, we will reimburse that entire money to you.
Yes.
My lords, he was paid 90,000 rupees
in the previous.
That was in connection with earlier bid.
Yes, earlier
two cases. In one case, 1,50,000 was paid. And in this,
they are not giving counter.
And my lords, what I submit, now the Tahsildar has become functional.
We do not know. We decided as on the date he had approached this court. Afterwards, Tahsildar may commit suicide. What we should do with that? The office will continue.
During pendency of the writ petition, it was transferred. The department was transferred.
Correct. By that, what happens?
My lords, now
if any department is part of the government only.
My lords, now the mining officer is competent to make payment if he is entitled to.
But that is not done, and therefore he is before the court.
My lord, no, he has not made.
Why a mining officer is a party? See that?
No, my lord.
Mining officer is a party. Only thing is you have to turn the pages.
The Tahsildar has collected the amount from the successful bidders. And
my lord,
not
there are three parties. One is additional district magistrate Kalahandi, sub-collector Kalahandi. Third is Tahsildar Kalahandi, my lords.
Mining officer is.
You are not mining officer. I read that once.
Yes.
Number 4 is mining officer.
He has not annexed that correct.
This is the writ petition. I am
no, after
consolidated page, he has not correct.
He will not correct. You have to correct or you should give the amended copy.
I have given, my lord. I have given that consolidated page.
How he can touch it?
No, he has not annexed that page.
He is reading your pages. Your pages you have given to him.
No, subsequently that was amended and that was consolidated page was given to him. He has not attached that.
Mining officer is also party. We will allow.
We'll take instruction from the mining officer.
How many years?
It is 20.
This is a money claim.
Why you should have filed this money claim only. People come to here for reputation, property, job, or money.
They have already collected. They have already
There may be disputed.
On the bidders, they have
collected. Disputed.
My lords will fight come.
If you file counter after these years, I will not permit that.
They have collected the fee money.
We dispute that. We don't dispute that. If he is entitled, Tahsildar has written that it has been transferred. Let mining officer say what action he has taken.
No, he has not said.
We will take instruction.
No, at this length of time we will not permit.
My lords, what I humbly submit.
How many years?
My lord, 5 years. 23, you have filed the case in 23.
How many years he should wait for getting 7.5 lakh rupees from you? Government, I can understand the people saying that I will not give money whichever you whatever you want to do. Government should be tall. It cannot treat it.
Provided he shows that the admitted amount is 7.5 lakhs.
He has said everything in the petition. You did not dispute it.
As per your letter, I have submitted my bill. That requires confirmation.
Confirmation means where you for so many years you have not filed it.
Your Lordship grant 2 weeks time, I will get it.
Where time is being spent only half hearing and arguing, people will be seeing all tamasha that is happening in the
No, my lords, in fact,
will be making comment on us.
this happened because the consolidated petition is not here. My lords.
You pay 10,000 rupees by way of course.
My lord.
Petition. Yes, the other government, not you.
2 years, your lordship. Do not.
Why? Within 1 week you have to file the objections under your rule.
My lords, I undertake will file within a week.
Therefore, we will give you
taken several times.
option now.
They are taking several times. If he is entitled, I will say that
Your Lordship, from the year 2024, they are taking times. Government advised to get instructions put of this matter on 18/4/2024. Thereafter, put of all the time.
Call this matter on Monday. Yes. At the request of learned AGA.
My lords, Monday there are holidays.
Monday holiday.
Friday is a holiday.
Friday is holiday.
My lords, Friday is a holiday.
Therefore, we have given you time now.
My lords, tomorrow is 4th. It is little more time.
Give 2 weeks. Nothing of government is reverse. Of course, all governments are like that only. Item 44.
44 similar.
2 weeks. Next.
Item 45.
45. Yes. In this case, the petitioner.
In that, in both the cases, the date will be.
16th. Yes. In this case, the petitioner is a retired teacher, retired since 31/5/2023. Any objection is filed?
My lord.
Yes, the objection filed. Yes. Now, my lord, I am only aggrieved. After my retirement, the letter come from the control of accounts for withdrawal of the money sanctioned in my favor. That is the revised assured career progression in the grade pay of 4,600, which has been paid, and I have availed that. After my retirement, in Annexure 3, page 27, 12/12/23 is directed that is wrongly calculated. It should be 4,200. That is also not a fact. Partition made, and a direction was also to recover the amount from my gratuity. As per the judgment of my lord Rafiq Masi and thumbs, so all these judgments, my lord, that cannot be recovered after my retirement. I am a pensioner. You are a pensioner. What your category? It's a level class 3. Class 3? Level 3, teacher one. Primary teacher. Class. Group 3 is. Sorry, group C. Rafiq Masi has given a side addition. For teacher, it is not exempting. No, Group C and Group D both all are exempted by the Rafiq Masi. Group C also? Yes, Group C and Group D. Take out that 2014 judgment. 15, madam, 15. Is chaos judgment? Yes. Sorry, madam. I've stated I didn't have the copy here, but that is the law in 2015. So 15, 4 SSC. 4 SSC 334, madam. Last paragraph, no? Yes, paragraph 15. Employee were wrongfully required to discharge duties of a higher post but has been paid. Recovery by what is the amount of recovery? My lord, that they have not calculated, but they've stated you revise his pay, her pay in 4,200 and got the recovery.
That is Annex 3, my lord.
No, employees of class 3 and class 4 service.
Yes.
Group C and Group C.
That is redesignated.
Teacher is
Group C. Group C.
Group C.
Yes.
Which are those rules? Under which rules? He is Group C.
That is, my lord, CCA, OCA CCA rule 1962. That is rule 8. The classes of employees that in a particular scale that is there in the.
It's based upon scale.
Scale.
Yes, what is the position, brother?
My lords, here.
And my lord, that fixation is also. They are saying also that a controller is saying that I am entitled to the 4,200, not 4,600. That is also wrong. Because of their own order, the DO, who is the bank's authority, he has rightly said, because as per the government resolution 6/2013, the finance department has issued that guideline.
6/2013
is the guideline. I have given that, madam. So CC ruled. CC ruled.
In one matter, we have extended, but some Samantre had argued that matter. I only remember that much. When we have applied Rafiq Masi, thereafter one more judgment came. I don't remember.
Thomas Daniel, that is
Thomas Daniel from Kerala.
Kerala, subsequent judgment.
Correct.
Yes, I have stated so much in the petition itself. Thomas Daniel is Civil Appeal 71150 of 2022 is the judgment. This is the scale, well, the Group C, how they have.
Group C, it fits into Group C.
Scale, yes.
Then Rafiq Masi applies.
This is not 2020.
If you make, alter the pay scale with retrospective.
My lords, what happened?
If you say that it's not a case of recovery, then I will dispose of that matter.
Here, my lords, we admit that there was mistake committed by the officers.
No, that is.
If he is entitled to 4,600 pay, he has to show that he is entitled to that.
No, assuming that he is not entitled. Only in that case, Rafiq Masi comes into play. Otherwise, not. If he is entitled to that question, will not arise at all. Assuming that he is not entitled to, he was not entitled to pay scale, but still you had given him. Only in this situation, Rafiq Masi applies, not otherwise.
Here, my lords, he is holding a post of
Group C only.
Group C.
Level 3 teacher. Group C.
Scale, that is there, which is that scale, my lord.
Because they are saying I'm 4,200.
Where is that group C?
That is, I have the he tested.
Yeah.
Yes.
Group C is basically is
my lord.
You're in what band?
I was in 5,200 to 22,200.
Level 4.
Yes. Then now it has been level 4. And then only after getting that benefit of what this, just I am to clarify the RACT first. Thereafter I will come to that one. Thereafter I get a promotion subsequently. That is up to the, they are saying you are in this scale, Group C scale.
No, this problem arose.
Problem just on scale. Yes, problem in this particular scale. So I was in the scale, just I'm clarifying 2 lines, probably I may not be clear if I will not say on this thing. But I was in the scale of this, what is there, then the book. I was not given any promotion. So I am entitled to that financial upgradation under the RACT.
Even otherwise you are entitled to that financial upgradation.
No. If only RACT is a scheme.
Promotion.
When I am not getting promotion, I am entitled to the RACT.
Correct. Provided you are entitled to promotion.
Yes, otherwise I am only eligible, but I was not given in promotion because dearth of post or something like that. I was given, sir, please. So I was given the benefit. I have clarified that facts in my rejoinder in one paragraph that I have stated, so I am just reading out the facts. In paragraph 3, I have just read out, I will get all the facts from that place. I will kindly see page 53, running page 53, para 3. My service career, I have noted it so in the rejoinder. Running page 53.
Rejoinder, good.
Rejoinder, para 3. I am just reading out that, I will get all the facts there instead of setting all these things. That the undisputed, shall I read, my lord?
I am not able to.
Rejoinder para 3. Rejoinder
to the counter affidavit filed by opposite party number 3.
Yes, madam. That is para 3.
That 11. There are three. There are three. Yes. My lord.
Undisputed facts borne out from the record and also admitted in the counter affidavit from paragraph 1 to 9 are that the petitioner was appointed as a primary school teacher in level 5 on 15/12/1984 and granted TBS scale of pay on completion of 15 years of service on 1/1/2002. Subsequently, when wrongly it is she was allowed the promotion to level 4 on 9/1/2013 and to level 3 on 24/4/2014.
Yeah.
These are the promotion. As per the Finance Department resolution dated 6/2/2013, the pay of the petitioner was further revised and she was granted the second RSCP in the grade pay of 4,200 on completion of 20 years of service on 15/12/2004.
1 second.
My lord, kindly see the dates here.
1/1/2002.
I got TBA. TBA was on 15 years. RSCP is 10, 20, 30 years of service.
Yeah.
So it is to be revised. I got the promotion, kindly take note of my lord, 9/1/13. First promotion in my life. I joined in 84. I got the promotion in 9/1/2013. So after 20 years I have completed on this date, 15/12/2004. That means prior to this promotion. So I am entitled to the benefit. The authorities
9/1/2013 you were given the promotion.
That was the actual date.
Level 3.
Level 3. That is level 4, my lord. Thereafter level 3 in 14. 24/4/14.
Level 4.
4 is in 14.
And level 3 is 24/4/2014.
Yes. So first promotion, I got it in 9/1/2013, my lord.
Correct.
I have started my service on 15/12/84. 84. So 10 years after RSCP says the first RSCP should be 15/12/94.
14/12/94.
Then another 10 years, my lord. 15/12/2004. So what? Because I have got the RSCP. So they
9/1/2013.
But I got it. So my RSCP was granted second RSCP from 15/12/2004 in the grade pay 4,200. Because I was in 2,800 grade pay at the relevant time. So next grade pay in the slab is 4,200. So I was granted by the authorities on completion of 20 years of service. And all these promotions got later to my entitlement to the RSCP. So it was rightly fixed on here. Now, kindly see, I'm just reading out further. Second RSCP in the grade pay 4,200 on completion of 20 years of service. That is from 15/12. But actually, though it was fixed from.
So what you say is, what was fixed as your pay scale is absolutely according to law. The question that they are assuming that it was wrongly fixed.
Yes, what actually the rule says, though it is fixed notionally from 15/12/2004,
actual benefit is given
to 1/1/2013. That is the government notification. So I have got it from 1/1/2013. So, but the promotion came on 9/1/2013, even thereafter.
With delay.
Yes, because that is the due course of promotion. But prior to that, all these things, all the confusion with the authorities because RSCP scheme came into force from 6/2/2013. All these fixation and all these things are done subsequent to that particular date, but from a retrospective operation because of the operation of law. So now all the confusion arises because of those promotions in 9/1/13 and 24/4/14. They assume as if I have got all these promotions after that benefit of RSCP. But RSCP entitlement
that only it was said, although it was notionally it was
done. That is it. I have given that circular. Shall I read that? That 6/2/13 circular. I have given it. The Finance Department notification. That says so. The financial benefit will only be from 1/1/2013. Can you have it, my lord? Annex 2, I have given that government resolution, Finance Department resolution. Page 21.
Yes, Para 3 makes sense. Para 3 of his affidavit Makes lot of sense.
All these confusion because there is a mix up of
my
things.
reasoning.
My lord.
And the government later, one more.
No, where is the fault in granting that pay scale to him?
My lords, we have explained in our counter.
Before that, I will just take one more document to my lord's would notice, my lord.
Yes.
Annexure 4, page 28. The BO, who is the concerned officer, who has granted me the benefit. Block education officer, page 28, annexure 4. In one hand, he has accepted all this factual position, what I have stated in para 3. But because this control of account, he has stated that no, it will be recovered. Kindly see, I'm just reading out a small letter. 15.324 letter. 15, annexure 4 in the writ petition. 15.324 letter of the block education officer Nimapara. This is a letter to the block education officer Bhubaneswar with regard to me. With referent Malagati. What I have stated from this document only I have stated so. With reference, this is the sanction authority who has given. With reference to the letter on the caption subject, I am to inform you that Sukanti Sahu, ex-headmaster level 3, was joined an assistant teacher on 1912-84. On completion of 15 years of service, she has been allowed TBS scale from 1912-99. Then after she got promotion to the post of level 4 headmaster on 8/1/2013. Since both the TBS scale and the scale meant for level 4 headmaster are identical, no financial benefit was given as promotional benefit. On completion, this is a clue, my lord. I will show. On completion of 20 years of service, she has been allowed second RSCP with effect from 1/1/13. As her pay was PB2 so and so. Grade pay 4,200 and has been fixed without increment since second RSCP has been allowed to her with effect on 19/12/2009 on completion of 25 years. She got promotion to the post of level 3 headmaster and joined as on 25/2/14. As she has been allowed GP 4,200 prior to promotion to the post of level 3 headmaster, no such financial upgradation was given to her on promotional benefit. Then after on completion of 30 years of service, she has been allowed GP with 4,600 on 19/12/2014. As third upgradation, which is the next higher grade pay of 4,200 as per the annexure 1.10 of Finance Department Regulation 6/2013. The said benefit has been allowed to her as per the due approval of the scheme committee. And kindly see para 10 of the government circular. What does it say? He has done it rightly. He has justified para 10, my lord, get it, page 23 of the Finance Department Regulation, annexure 2, page 21. It starts with that 6/13 Finance Department Resolution, para 10. How it is to be done, that is clarified. Para 10, page 23, man.
Benefit of pay fixation.
Benefit of pay fixation. What does it say? Just I am telling in one line. If somebody is given a promotion, but he will not get any promotional benefit because under the rule, the service
promotional promotion.
Yes, promotional benefit. Once I am getting a promotion, I am to get my pay is to be fixed with additional of 1 increment. That is 74, rule 74 of the Orissa Service Code. But if I am entitled to the benefit of RSCP, I have to forgo that part. And in fact, as is stated by the authority, I have not given any promotional benefit like that additional increment. That is why my pay was fixed in the RSCP. That has been stated here. Kindly see, man. Benefit of pay fixation available at the time of regular promotion shall also be allowed at the time of financial upgradation under the scheme, which means the pay shall be raised by 3% of the total pay in the pay band and the grade pay drawn before such upgradation. The employee of the cadre having a promotional hierarchy will get the grade pay of the promotional post. The employee in isolated ex-cadre post not having any promotional hierarchy will get the next higher grade pay as per the first schedule of the ORSP rule 2008 with the interpolations, if any, introduced subsequently. In case of new grade pay corresponds to the different pay band, the employee will get the pay band corresponding to the revised grade pay. There shall have been no further fixation at the time of regular promotion. I have not get any benefit of the promotion. Even if I got the promotion, I didn't avail any benefit because I have availed the benefit of grade pay under the RSCP.
Since promotion was given during that period only notionally.
Yes.
Since you did not draw
any benefit, 3%. I got the RSCP
to that.
And I retired with the benefit. My authority annexure 4, that is why I am
retired on which day?
31/5/2023. But I am yet to get my gratuity and all other pension, and now with the saddle with this recovery.
Once I will apply for gratuity, then automatically they will deduct whatever they want. But legally, I am entitled to the benefit what is paid to me because I have not get benefit of the promotion. Any salary benefit, financial benefit, because I have availed the benefit of RACP. This is the rule. What's your
my lords? I less para 7 from 7 para 7 of my counter. That it is further humbly submitted that the petitioner was promoted to the post of level 4 headmaster by the order dated 9/1/2013 of the DI of schools.
Four of your
yes, four my lords.
7 is saying.
From 7, let's say it will be subset. My lords, para 8, it is simply submitted that after introduction of RACP scheme by the Finance Department resolution dated, certain doubts were arose with regard to the implementation of RACP scheme in respect of different state.
That clarification that sought for and clarification has been granted.
Then my lords,
to help you.
My lords, para 9, my lords.
Para 9 is what is para 3 of the affidavit.
My lords, it is humbly submitted that in introduction of RACP scheme resolution and upon approval of the screening of the BEO, Nimapada allowed second financial upgradation RACP at the rate of grade pay of 4,200 with effect from 1/1/2013 by order dated 8/9/2014. Subsequently, the BEO Nimapada by order dated 2/3/2015 allowed third upgradation by allowing grade pay of rupees 4,600 in favor of petitioner. Further, the petitioner was promoted to the level 2 assistant block education officer.
Correct. But without that is nothing to do.
My lords, this assistant block education officer carries pay scale of 4,200.
4,200.
Great.
That
we have stated. That para 10.
No, 4,000.
Para 11 year lords. It is only submitted the Director of Education Odisha clarified that the teachers who were initially appointed as primary school teachers upon completion of 30 years of service is eligible to grade pay of third promotional post level 5 assistant, which is level 2 ABEO, which carries grade pay of rupees 4,200. But not allowing grade pay of 4,600. This is the reason, my lords, why the pay needs correction. And then, my lords, para 12, the government of Odisha in the power conferring constitution.
What it is stated may be permitted, man. Kindly come to para 11 of your objections.
My lords, that I am pointing out. It is only submitted here that the Director of Elementary Education clarified that the teachers who were initially appointed as primary school teachers upon completion of 30 years of service
is eligible for grade pay of the third promotional post of level 5 assistant teacher, which is
level 2 ABEO. He retired as ABEO level 2, which carries grade pay of rupees 4,200.
That is a completely affair, my lord. This they have confused with this only. This promotion in 2021, my lord. All this fixation was in 2014 or 13.
what they say that because I am not getting also any promotional benefit of this ABU because I have availed the benefit under the RSP scheme. The distinction in the RSP scheme, my lord, kindly see this. If I will give an example of class 1 officer and the class group C and group B post. My lord will understand what is the law here. My lord, the grade pay is like this. 9,300, 34,800, that is slab, 39 scale, but the grade pay is 4,200. The next grade pay is 4,600. Next pay is 4,800. Next grade pay is 5,000. Yes, 5,400, and then is the 6,000. Like this, 7,700. All this thing is there. Suppose a person appointed, but this 5,400 is a group A post. That's the basic pay of the group A post. But suppose a person joined in the 4,200 grade pay. After 10 years, under the normal understanding, under the RSP, after 10 years, he will move to the 4,600. After 10 years. 20 years, he will go to 4,800. But in the 30 years, he will jump to the 5,400 grade pay. What he will get is 5,000 grade pay. Actually, the grade pay is this. The scale will move. Scale is 15,100, where it is less than 9,300 scale, group C post. Group A, that is 15,100, and the slab is up. But he will get this 9,000 basic pay, but the grade pay will go up to 5,400. Only the benefit is in the grade pay, not in the scale. What they have confused is because my promotional ABO post is a higher post. There the basic grade pay is 4,200. If you have got it in the RSP, because RSP is that way, you have fixed. So if I have got it the higher grade pay in the lower post, that is because I have completed 30 years of service or 20 years of service, whatever it is. So you cannot say that because it's a higher pay, it is higher scale, higher post. The grade pay is the 5,400 or the 4,200. So you cannot get it prior to that. That cannot be the RSP scheme, madam. RSP scheme is different, madam. That is why an employee is not granted the benefit, double benefit. Once you have availed the RSP, you have to forgo the promotional benefits. I have forgone all the promotional benefits. They have not granted me. It is the candidly admitted in the paragraph 9 of the counter, as well as I have clarified that in paragraph 3. And that annexure 4 also justify my claim. It is rightly fixed it. Then my salary, I was in, my lord, in 2,200. I have started my service grade pay of 2,200. Thereafter it went to 2,800. After 2,800, my lord, the next grade pay is 4,200. That in between, there is no grade pay in the pay scale. So I have got it. After 20 years of service, I got the benefit of 4,200. What wrong the authorities have committed? Because this control of accounts, all these things happened after my retirement. And that Rafiq Masim, paragraph 15.2 also says, Group C, Group B, and clause 2 also says, it should be all the retired employees. Well, I am reading.
Brother Rafiq Masi, that there are 3 classes of case. Go to last
yes, ma'am. I am just reading out, madam.
1 second. Kindly come to
Para 12.
Para 12I.
Yes.
Roman 1.
Yes, it is.
Recovery from employees belonging to class 3 and class 4 services
or Group C, Group D
would be impermissible in law. Last paragraph 12, just read that. Why all this I should discuss? Because if I discuss this, best other people may come forward saying that whatever has been given to him should be given to us. Therefore, best way is to put this headache away by referring to paragraph 12I. Roman 1.
And 2 also says that recovery from retired employees or the employees who are retired 1 year.
No, but if that is taken, that will be horrible.
That also they said so. I am just saying the Supreme Court, what the Supreme Court says. Even I am not there, my lord. A group employee, he can also take advantage of this.
Assuming that your paragraph 9, 10, 11, in contrast with para 3 of his rejoinder, assuming that you are right, still this will come in the way. Since you have argued, perhaps I have to touch it, and that may open up the floodgates.
Yes.
Others will come forward with that claim itself now. Those who are working now. They will say, we are ready because you have already upheld the claim of Mr. Das' client. Therefore, we are entitled to that particular paragraph. Since you argued, I have to treat it now. Therefore, I leave it to your wisdom, what I should do.
My lords,
Your apprehension is
my lords, whether
my judgment may give rise to right to others is your apprehension.
My lord.
But that is because you are inviting all these problems.
My lords, what he has upheld both leaders. He has got RSCP.
No,
promotion.
I am in agreement with you.
My lord.
What are you saying about 12.1? 1 and 2 also. He is going further. 2 also. Maybe in one matter we applied for group C, group D. This rules for all.
It is whether this particular case will come under group C.
No, it is material there. 2. I saw that. I verified. See touch.
4,006.
So see. Just look into this. Yes, given that.
Yes. 2008 ग्रेड पे थिला एथरे कोन दिसला कि 2008 ग्रेड पे सेउडा थिला सु यार तो करेस्पोंडिंग स्केल टा इतरे
करेस्पोंडिंग ग्रुप
2008 ग्रुप करेस्पोंडिंग टीचर टा अपन जानन ग्रुप से बोल
अरे मैं तो ना बोलू तो जीएसटी
This para 12.2 of my topic, my lord, economic subject, my lord's approval. It is for even the group A employees also. They are saved within 1 year. 1 year, they are saved. They from them also there cannot be a recovery. And that is reiterated in Kerala case. Thomas, yes. Do you have that Thomas statement with you? Yeah, no, sorry, I have stated, my lord. That is there. I am just getting it. Thomas Daniel is, my lord, civil appeal number 71150/2010, disposed upon 2522. Sorry, I will get it. They reiterated the same thing. At paragraph, just a at paragraph 18, well, petition is allowed in the light of 12 Roman 1 and 2 of Traffic Mercy, which has been reiterated by the Apex Court in Thomas Daniel versus State of Kerala. No neutral citation.
My lords,
no,
here 1 year is not over, my lords.
Huh?
1 year.
No, Roman one itself will be applicable. One itself will be applicable, and I have gone further because one more leverage is there in Rafiq Mercy.
My lords.
Go to para 12 of Rafiq Mercy. Recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is made. Which you want to rectify now, which was given in which year? 2014, 2013. 1/1/2013. It has been paid.
No. You are retired only.
No, not
retirement.
with the retirement. RSCP. Kindly see that. Come to 12.3. RSCP.
My lords, that
recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. You have issued order of recovery subsequent to retirement.
My lords, but
10 years after. Perfect. Mercy, paragraph 12.1. In as much as petitioner fits into class 4, that is the group C, in view of the
my lords, para 9,
nothing like that. Group C of rule of the government inspection dated 9th February 2018, wide table 4. Table 4. Okay, this also take that one. Next one. Even otherwise, yes, petitioner, case of the petitioner travels to 12-3 in as much as the concerned pay scale was accorded to the petitioner way back in the year 2013, and therefore the 13, whereas the recovery order has been issued after retirement, which is obviously beyond 5 years. First one. Refer to next paragraph. The ratio in Rafiq Masi has been reiterated by the Apex Court in Thomas Daniel.
This 2022 SCC online SC
2022 SCC online SC
536.
536. Yes. 536. Any amount is recovered now? No.
I have not received. Once I will apply for gratuity, it will be recovered.
Yeah. What is your prayer? Only requirement of recovery or direction for
and for release of the benefits. With interest, I have said.
OP number?
OP number, my lord, this. Actually, this now this block education officer Bhubaneswar is the authority. Last OP number 5.
4 also, no?
Yes. 4 is the 4 has passed that order. 4 and 5.
The writ of mandamus issues directing respondent numbers 1, 4, and 5 to release your gratuity amount.
Pension, gratuity, nothing I haven't received. Only provisional pension.
All terminal benefits to the petitioner by issuing final pension payment order. Interest. All these years you have not given the pension at all.
My lords, she has not availed pension because that will be deducted, my lord, in apprehension.
What apprehension?
What? You should have credited it to his bank account.
Well,
whatever amount was payable by him, you could have deducted. Rest of the amount you could have.
My lord, before it is determined, he approached this honorable court.
No, I filed in 24.
Yes.
I retired in 23.
He retired in 2023.
My lords.
And
impugn order was passed in.
Padmanabhan Iyer says, since date of retirement is known on the basis of date of birth, 6 months you have to keep the papers in ready preparedness.
My lords,
my lord, recovery order passed by the controller. Annexure 4.
Controller of accounts
passed the order on 15th.
Pointed out the defect in December 2023.
24.
23.
No,
correct.
My lord.
Yes, sorry.
All right, notionally you should have calculated so much amount is not payable, rest of the amount will pay you. Suppose a person is entitled to ₹10 lakh in refund. You say, no, he is not entitled to 10 lakh, but he is entitled to 10 X minus 10 lakh, 10 lakh minus X.
My lord.
Can you say, no, you are since you are liable to pay so much amount,
because of the pendency, then
who said, who asked you to pendency? Because of your act. Where have you come forward with your fairness in your counter? You are treating as if you are a commercial bank. He is your employee.
My lords, it is not disputed that is not entitled to.
Correct, but
My lord.
whatever amount is he is entitled to, so much amount you should have released in his favor. You are paid a provisional pension.
Yes, provisional pension, that is, I am getting.
He is getting.
Provisional pension is on par with full pension only.
Not less.
How much
At
less
least,
than?
2 to 3,000 less.
That is all.
Yes.
Only DCRG, the only
Other things, madam.
What is that? How much amount is paid?
From the date of retirement, I am getting the provisional pension. The gratuity amount will be now after the enhanced rate, my lord, it will be 15 lakhs. And other leave encashment or other benefits, my lord.
Where have you stated in the petition?
No, I have not stated because.
But if you say orally all those stories, how I should take those? There can be fables when I go to the bed. But in court, your case should arise from the pleadings.
Only I stated that because I have not got anything except the provisional pension, I am entitled to the delayed payment. For 1 year, I am not entitled to the interest, my lord. As per the rules, my lord.
After 1 year, you will
1 year, I will get the benefit.
You will be entitled to interest at the rate of 6%.
7%. 7%.
Interest at the rate of 7%.
After
accruing 1 year after retirement. All right. So, since these rules are, I am stranger to your rules. I take more time than usual.
Another case of coordinate bench has decided on the item, the WPC 6293 of 21. There, my lord, have also taken note of one Jagdish Prasad. I will give that.
That is the judgment I wanted.
Jagdish Prasad.
Somebody had argued that matter.
The 2024 SEC online is 1909, where the Honorable Court has held, Honorable Supreme Court has held that nothing can be recovered after a person is retired.
That will be an extreme proposition.
That is the extreme.
But my judgment, with some I don't remember correct name, he had argued. Your names are also very difficult for me to store in my memory font.
But it is much difficult to remember, my lord, that South Indian's name.
For you people, yes.
Very difficult for us. We have a title here.
Correct.
It is easy to remember, at least.
You are all calling me as Shripad. I feel very happy because it is my late father's name.
But Dixit is a title here. All the Brahmins are Dixit. All the Dixits here, they are Brahmins.
Yeah, Maharashtrians are there.
No, there are Dixits are all over.
Dixit are Brahmins.
In Andhra Pradesh, they become Dixitalu. Little change that way. That is Kashinath Dixitalu. You have seen that judgment?
Yes. Our is title, that is.
7%, 1 year after retirement.
No bless.
Yeah.
Item 47.
47.
46.
Yes. Yes, brother.
Petitioner is the opposite party. I'm from the opposite party.
Your petitioner is not here. Call this matter after 3 weeks to enable counsel for the petitioner to come and argue. Yeah. Next.
Item 48. This is my lord.
Your lordship, item 48, we are appearing for opposite party number 2 and 3.
Can you get that segment which I wrote?
Tomorrow morning I will do.
No, today I have to complete and before I go home, I will get. I will approach them and I go.
I'll just after leaving the courtroom.
Your lordship, may I make a prayer?
Yes.
I pray for 2 weeks time to file the counter.
Counter you are not filed.
Counter has not been filed.
All right. 2 weeks for filing counter as requested. Filing which? Yes. Call up 4 weeks. Next.
Item 49.
Two petitioners, my lord.
Yes.
The scheduled caste persons. Only because they are scheduled caste, our merit and seniority ignored, and my juniors have been given promotion. That is, lordship, my lord. First, the annexure 1, page 9. My selection, my merit list, my lord. At page 10, I placed at serial number 12 and 13. Page 10, my lord. That is merit list, my lord.
relevant 13 or
Page 10, my lord, is select list, my lord, merit list.
final select list.
Final select list, my lord. On merit, my position is 2 petitioners and serial 12 and 13.
You said page 9, na?
Page 9, the select list, my lord.
Once.
At page 10.
At page 10 you appear.
Yes, my lord. Final select list. Page 10 is the final select list, my lord. Yes. Yes,
relevant 13 are your clients.
Yes, my lord. And serial
both are scheduled cash.
On merit, serial number is merit position. From 14 to 21, they've been promoted, my juniors, my lord.
14 to 21 are promoted.
Yes, my lord. I've been promoted. I'm showing it, my lord. Then I will see, my lord, gradation list.
At page 22.
At page 20, it starts from page 21. My position, my lord, is at page 24. Page 24. Page 24, serial number 36 and 37. And the opposite, private opposite parties, my lord, they placed at serial number 38, 39, 40, 41, 42, 43, and 44. Those juniors, my lord. They have been promoted.
Promoted, who are those promoted?
Promoted the opposite parties. I have made them opposite parties, my lord.
38 is not.
38, 39, 38 is opposite one 3, 38, 39, 40, 41, 42, 43, and 44.
Respectively, there will be OP numbers.
OP numbers, my lord, given, my lord. 38 OP number 3, 39 OP number 4, 40 OP number 5, 41 OP number 6, 42 OP number 7, 43 OP number 8,
Shubhangi.
Yes, madam, Shubhangi. And 44, next page,
9.
50, 9.
What is the reason they have given?
In counter, government says, my lord, this is down to page 46, paragraph 7 of the counter affidavit.
Paragraph 7 of the counter.
Counter affidavit.
That with regard to the averment.
Yes, madam. With regard to the averments made in paragraph 6 to 11 of the writ petition, it is submitted that the promotion cannot be claimed as a matter of right. As submitted in earlier paragraphs, due to non-availability of vacancy in his respective reserve category, that is SC, the petitioner's case for promotion to the post of lecturer stage 2 was not considered. We are senior, more meritorious, only because our AC were ignored. That is the only stand by the in the counter matter, counter of the government. And the rule, my madam.
Rules say.
Yes, my lord. I'm saying the rule, my lord. Rule, my lord. LRC page 31 is the rule, my lord. Annex of 6.
Page 31.
Yes, madam. This is called Orissa Civil Services Criteria for Promotion Amendment Rules 22. This amendment rule, rule 3A.
Capital.
Yes, ma'am. 3 capital A, the proviso part.
It's 30.
31. Notwithstanding anything contained in the relevant recruitment rules, where the promotion is to be considered as per the post-based reservation by way of replacement theory, the separate zone of concern shall be applicable, provided that the scheduled caste or scheduled tribe candidates appointed on their own merit, either by that.
This rule is made pursuant to Indra Sahani.
Yes, ma'am. Yes, ma'am. Indra Sahani. Then the government, GA department clarification, my lord. The next page. Annexure 7, page 32. Government, the clarification, the question, the second, next right-hand column clarification, let's turn to the bottom line, my lord. It is reiterated then. The clarification part, page 32, bottom line, my lord.
32, bottom, it is reiterated.
Yes, reiterated that
UR
is not a category.
Because of Ajay Singh case.
Yes, madam. In itself.
To all the so-called reserved category, even an NCST candidate can be considered under the unreserved post terms. That's in the sun. It is
yes, in the same.
Here that the direction of honorable court in the case of not. From amongst the members of the reserved category. Against unreserved post in the event of their appointment, the number cannot be taken into consideration. So it's the same have been clarified into P capital A. So perhaps this problem arose because they considered UR category as a separate category.
Yes, yes, ma'am.
That is the problem.
Not they agree by seniority. I am senior. I am not claiming any reservation since my senior is there. I am senior and also meritorious. In military, I am in higher position. In seniority, I am higher position.
Since you were more meritorious, you have been deprived of the benefit of reservation.
Then again, this is the clarification. This is the clarification of GA department. Then again, Annexure 8 is the clarification of the SCST development department. By now, they have sought for clarification from the law department. Page 37, Annexure 8. In General Singh, they are referring General Singh case, the clarification
page
it starts from page 37. The ACSC Development Department, and in from page 38 onwards, my lord, they sought for the clarification of law department. The law department clarification starts from page 38, and the relevant portion is at page 41. Page 41, my lord.
41.
Yes, my lord.
Note sheet.
Note sheet. In the above discussions,
we have availed reservation appointment following seniority above the list. Unreserved candidate will be promoted against unreserved vacancies.
Yes, yes.
Treating them as on own
merit.
Sorry.
In government counter, my lord, in paragraph 7, only because I am SC civil caste category, I was not allowed promotion against unreserved post. That is the only stand in the counter appeal.
Wrong. What do you say?
Annexure 8 has been withdrawn, my lord.
Annexure 8.
8, my lord.
Even otherwise, that will be the position of law. Annexure 8 only reiterated what Indrasani said.
Yes, my lord.
In Indrasani, what Apex Court said was, there is a reservation. Okay?
Yes, ma'am.
How many, what is the 27% or so in your state? Which is that some judgment said it cannot exceed 27% or something like that. But anyway, the unreserved candidate cannot compete with reserved candidate. But reserved candidate can compete with unreserved category. Suppose if he scores more, he will be accommodated in the UR category. Okay. He was more meritorious and therefore it happened. But when you are considering for promotion, you cannot treat him
as a reserve candidate.
You have to treat him as a reserved candidate.
Yes.
Merely because he was more intelligent by accident and by his hard work he got appointment. Being more meritorious than general category, you call it as you are, unreserved category candidates. You can't deprive him of right to promotion, which otherwise avails to the member of the scheduled caste, scheduled tribe. That's what Indra Sahani says. One of the sayings of Indra Sahani. Thereafter also there are judgments. Many judgments are there clarifying that. Otherwise what happens is, you will be punishing him for being more meritorious, although he is born in that scheduled caste community. Any latest judgment of the Apex Court?
This Hon'Ble Court, my lord.
This court is already answered.
Let's see from paragraph 5 onwards, my lord. From paragraph 5 onwards.
It is a gross injustice to scheduled caste and scheduled tribes. Completely misconstruction of the law by the state government.
From paragraph 5 of the judgment, court's reasoning and analysis.
Paragraph 5.
Yes, my lord. Page 6 of the judgment. Paragraph 5 onwards, my lord.
This is the judgment I was speaking from. This is a similar view is already taken by the Apex Court. Sabharwal. When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserved point, it has to be taken that the posts shown at the reserve points are to be filled from amongst the members of reserve categories, and the candidates belonging to the general category are not entitled to be considered for the reserved posts. On the other hand, reserve category candidates can compete with non-reserved posts, and in the event of their appointment to the said post, their number cannot be added and taken into consideration for working out the percentage of reservation. Article 16(4) permits the state government to make any provision for the reservation of appointments or posts in favor of any backward class or citizen, which in the opinion of strikes. So, R.K. Sabharwal.
This matter for the opposite party, two sets of lawyers are there. I have appeared for OP number 6, 8, and 9.
Yes.
And they have filed counter.
Yes.
So today I am handicapped.
No
handicapped in this.
That you should say when opens. Otherwise, I will be wasting public time.
Yeah.
I will be very happy to sit, talk, and go. But I will not. I cannot do it as a judge.
But I beg to submit.
Yes.
I have not got instruction. I have got technical reason because ladies they are serving Kandhamal.
We do not know all that. You can serve
what I beg to submit. Today I am handicapped in this sense. I don't know.
No, that you should have said before he opened his mouth.
No, but I
Having allowed him
no,
to
but I beg to.
Last me read that, my lord.
I had taken time. I felt myself guilty to pray for time. That is the only thing. That's why I said this is the position. Still then, on the basis of one counter from the state side, one counter from the other set of lawyers. But on the basis of their I will just submit. Then thereafter, if your lordship feels that 1-2 weeks time is necessary.
No time will be granted. No time will be granted.
Yes. Then your lordship may kindly see.
Yes.
The paragraph 6.
Now we are asking you whether other vacancies are available now, so that without disturbing them, if at all, if you are agreeable, so that already they are holding posts for the year now. Instead of my passing an order, again that order being put into appeal, this is risky.
Yes,
I am not
I agree to it, madam.
Therefore, the best way is to accommodate them in the vacancies available. You have punished them for being more meritorious. That you cannot do. The object of reservation is to benefit them. On the other hand, you have not only not benefited them, you have deprived them of whatever was legally entitled to, because they are more meritorious. That's not the object. This is what R.K. Sabharwal says. You are two. But why you want to displace 9%?
Well, all are juniors, my lord.
That's all right. All right.
No, not right. I don't want to displace them, my lord. I am showing my seniority. Even apart from merit, we are also senior to those persons, my lord. In gradation list, we placed above them.
Your grievance is as to non-granting of promotion or non-granting of gradation in the list?
No, my grievance is non-granting of promotion, my lord.
Promotion.
And prayer is to give me promotion from the date my juniors are promoted.
If that is done, you will be happy.
Yes, ma'am.
Then why you want to argue?
I said I am handicapped, that's all.
But where have you stated? What's your prayer?
Page 7, my lord. Page 7 of the petition. First prayer to quash the promotion order given to the junior. The second prayer, my lord.
But treatment will consequent service of monetary benefits. So you have not challenged their promotion.
Yes, I am challenging it.
Where have you challenged?
Well,
impugned order.
Impugned order, my annexure 5. That their promotion order, my lord.
But you want to give up number 1 and adhere to number 2.
Naturally, my lord.
So that once for all some resolution of the dispute happens.
Yes,
you would just file a memo saying that my clients will be happy if they are given promotion from the date the juniors are given.
Yes.
Prayer number 2.
That is prayer number 2.
That's one.
That is prayer number 2.
File a memo saying that you are giving up the first prayer.
Yes. And also my in promotional post, my seniority will be above them.
That would create.
No, that is because in the lower post, I am senior.
If they are concerned with the same date, all the consequences would follow. That if they are
no, just think. Don't do it because I am a suggestion. Think now. If you say that you should be appointed with effect from the date the juniors have been appointed, no, then he will be senior.
Yes.
At the most, you can retain the post. But so far as seniority is concerned, you can. Otherwise, he will not have any justice at all at the hands of this court. Even seniority has to be given to them. Yes. Otherwise, you will lose the post only. Instead of that, what we are saying is, you will retain your post, but the seniority will be given to them.
Above us.
Yes.
That
will affect your clients.
But
the only thing is, your clients may retain the post because of the concession he is showing now. But you will be pushed down.
With that 2-3 days time?
No, I will not. Never. I will never do that. But at the earliest point of time, if you ask, I have given time, even when 2015 matter. After having heard you, they cannot do that. But that concession, you can, so that you can retain your post. Otherwise, post only will go.
Your Lordship may kindly see. Posts are there. if their prayer number 2 is considered, and if they are given minor promotion from the date juniors, in fact, my clients have got, my lord, the problem would be solved. If now my lord would say that seniority, that would give an overlapping effect.
That is my right. What to realize is that you have appointed me as a judge because I will decide things according to
only one thing. Apart from other thing, your lordship has said the position of law. Only their statement, everything made has not been given a go by. My lord, in all annexures 6 and 3 annexures, it is referred, selected on merit, but in related to initial recruitment, their initial recruitment is on the basis of reservation. Only that is the distinctive feature. 3 annexures they have relied. If they are on merit means not on merit. My learned friend has referred to one annexure. Against that serial number, the endorsement is missing. Endorsement is category. Category is prepared. Reservation is claimed on the post-based vacancy. Schedule caste, what is the vacancy? Schedule type, what is the vacancy? Unreserved, though they are not category, what is the vacancy, number of vacancy? It is being notified, and gradation list, they might not have a challenge. In gradation list, placements are there. Against the serial number, my category is there. My lord, if initial recruitment is not on the basis of merit, all the 3 annexures they are relying, if they are selected on merit, your lordship, then thereafter I am leaving totally to my lord. So seniority, it would have an overlapping effect. Now, my lord, if from the date, usually it is prayer.
In other words, I'll tell you, if they are more meritorious in the open competition, they get the seats in the unreserved category.
Everything I will bow down. If your lordship kindly just grant me 1 or 2 days time, no, I may be misunderstood.
Yes, I will agree with you if you do not put forth that prayer.
No question of no question. Your lordship's expression, I am just placing. It is ultimately my lord's sort. Your lordship mechanism. My lord, the ladies candidates remain for technically they are not. I want to just get telephone from them. Just Monday, if it is kept, or Tuesday, your lordship may kindly see if this prayer is allowed, that I may be misunderstood. I don't know what is the far-reaching consequence. I have to take instruction on that. But usually in promotion matter, your lordship knows prayer is made. I may get promotion from the date by juniors. That part is granted. Nothing to say. It would refer to the one date. One date I have got, you would be retrospectively getting that year with all benefits.
No, on the same date, he is to be granted.
Yes. Vacancy is there, it can build up.
No, not only that. The question is, on the same date it has to be granted, then he will be seniority because his seniority is approved.
Not seniority with all respect, I would say. So, if your lordship just grant this pair, and
see that. When you come to the merit, the final selection, he is above you.
Yes. Kindly see. 13.
10. 12 and 13.
13. Again, 13, it is vacancy in SC category.
Yeah.
That is the select list recommended by the commission.
Correct.
Appointment on that basis. Appointment because of the fact that he belongs to the reserve category.
Correct.
Having got benefit in the course of initial recruitment, then him subsequently in promotion, everywhere the rule says on which the reliance is being, the rules consistently says that if they are selected on merit, if against scheduled caste candidate they have been selected, if my lord should say that they are on merit, they are not on merit. Cannot be given a go by, but replacement theory is there. 2 can just come below replacing the bottom 2. That your lordship knows, bottom 2. So that gradation list, bottom 2, if you replace, I have nothing to say, but it may lead to further legal complications. So if you kindly consider to grant prayer number 2, that is usually made. But to the future consequence, my learned friend is making a prayer, but I would say that I would not be misunderstood. I would just ask them. The Honorable Court, in fact, has expressed the view, what you have got to say. But if court's dictum, my lord, I would have asked.
Court's duty is to determine.
Yes, my lord, much over. Lord, I would ask them, my lord, ladies, my lord, they would misunderstood me.
No, let them misunderstand. I will be misunderstood.
So paragraph
If a lawyer is misunderstood, nothing will happen.
So
if
prayer
is misunderstood.
Prayer number 2, your lordship may on their.
What do you say?
Yeah, number 2 also I have prayed with all consequences.
You have made prayer is all right, but he is saying that you are selected under the scheduled caste category benefit only.
That is my merit position. Even Silkas, my lord, on merit I am above him.
No, merit is
merit.
Merit. That is against serial number 13. Yes, second column. That will depend on the submitting.
Only because I am SC.
Number 13 against SC. Then you let our starts on the 2 persons against SC. Having taken benefit above all, though they were below in the initial merit list when the initial recruitment was made.
Where is that?
In that appointment order and instruction they have not filed.
No, if you are taking up that.
Yes. On the basis of instruction, that is I could not have that. That is on the basis of instruction.
No, otherwise also it makes no.
Your lordship, this is the recommendation list.
Sir, what do you want to suggest? But if I decide that,
yes, ma'am.
I will decide according to law is another thing. Yes. But that will only lead to another battle.
Yes, let them go. I don't want to just trouble them, my lord. Yes. No, you know, how can I be? I can't.
Then further action
must be from the date of there, and my senior must be right. Once I got promotion, that is my prayer number 2, my lord.
He is not having any seniority. He is not having any seniority.
First, I consider, my lord, without passing the promotion order, my lord, I may be given prayer number 2, my lord.
From the date.
You write that in your memo.
Well, when this selection list was forwarded to the government on the very basis.
The government does very wrong things. I have seen. Government does.
But
this is law is decided in.
Yes,
in
it is the appointment order would indicate on that basis the recommendation that you are appointed because you belong to scheduled caste. You are appointed because you belong to scheduled tribe. So how do you take it? That is consistently the judgment also. This court judgment, my lord, when my London friend had submitted to your lordship, kindly see, it is also said.
Result.
I'm just giving you a moment.
You can see you then.
Yes.
Another aspect, my lord, in the impugned order, my lord, in page 29, my lord, promotion to the post of lecturer stage 2, they are allowed to continue in the present place of posting until further orders. And further, my lord, the promotion is subject to concurrence of UPSC and final outcome of WPC, number such and such.
So that is made subject to list pendants only.
Well, then other petitions.
Other petitions are there. What happened to those petitions?
So that is only I have brought my lord's notice.
Whatever is there.
The only submission is that my London friend is there.
You should make prayer to him.
We will talk to each other. We will talk to each other. We want a compromise also. Seniority would be an overlapping and far-reaching consequence.
What he says is, let you be promoted, no issue. But seniority you will not get. This is contention.
That is my right, my lord. Since I am senior in the lower post, in the promotion post I am senior.
Not a lower court. That is in your vacancy. In your vacancy. He has not raised that when getting the first appointment.
Gradation I will you.
They are below me and getting appointment and
where below? They are above you in the gradation list.
Gradation list
they are saying should be above.
Gradation list is also the vacancy. Gradation list is also concerning vacancy.
I agree.
It is a problem. But my lord, prayer number 2, my lord.
Let us. Yes.
Item 50.
Whatever due to them, I cannot deny. Whatever is due to them under the Constitution, how can the government deny all that? Because it's a larger policy which Dr. Ambedkar and other stalwarts have made in the Constitution. How can we deny that constitutional right to them?
And I got affected from the date.
Yes.
Item 50, file, my lord. I have not received the file, my lord.
50?
Item 50, my lord. I have not the file.
3 times your lordship, at least your lordship granted 2 times, 1 week, which I have already retired, and it's a case, for suspension period, payment is to be made.
You can give one more, 1 week you give him.
Leave it to your lordship. As a last occasion, as a last chance.
As a last chance. 1 week for filing of objections. Yes.
Item 51.
May it please the conflict. I am for the petitioner, your lordship.
Yeah.
Here I am challenging the revised plan issued by the BDA.
Lordship, I'm appearing on behalf of the OP number 3 and we are filing the Wakalatnama today. We're seeking 3 weeks time to file a reply.
Mrs. What is that?
Mrs. Prakriti Patnaik.
Mrs. So finds power on behalf of
OP number 3, the builder.
OP number 3, Nilanchala Buildtech.
Yes, Your Lordship.
OP number 3, and seeks 2 weeks to file objection. Counter. First of all, up to 3 weeks. Yes.
Under item 50 will be taken up on 10th of September.
10th of September, right? 10th of September. No. On 13th of September, we take that. Alright. 13th holiday. No, sorry. 13th holiday. 15th of September, we take that. Yes. Your case is that you cannot be compelled to take the leave. That's your case. Is it?
Only suspension period.
That's what it is. They cannot treat that prayer. Once you emerge victorious in the proceeding, they can't say that
there is no proceeding at all.
Proceeding at all.
Yes.
Reverse.
Suspension after 3 years.
Correct. Yes. 50.
Item 53.
52. 52.
No, I am 52. See, 51 the time level, not 52.
Yes.
I am 52.
52 will file counter, my lord.
3 weeks for filing counter.
My lord, Lordship kind of short answer because his petition is relative to the 5th application. 5th time has approved this annul since 2016. 2 times before the tribunal, 2 counter petition has been filed. There is a 3rd one. The rejection order passed earlier by the state opposite party again reiterated the same, even though the same was set aside by the honorable court.
Finally, 2 weeks to file objections, failing which the petition amendments would be taken with the face value. May be taken with face value.
Fix a date, your lordship.
Yes. 25?
Obliged, also obliged.
Item 53.
One submission. In this matter, milords, I have appeared on behalf of opposite party number 3. My learned friend has served a copy on 18th August. I played 2 weeks time to file response.
May I play one too? My lord, what is impugned in this petition?
Yes,
just one submission, one line. He has turned out to be a nemesis of the entire education department, your lordship. This is a gradation list which is flawedly prepared. On that basis, you're making everything subject to this writ petition. They're going on giving illegal appointments every now and then. Only my prayer, my learned friend might take as much time he wishes. Only that further illegal appointments may not be kindly given on this particular gradation list.
We'll give you 4 weeks. But not to give any other point.
Private opposite party. It is the authority.
They have given the counter, have given the result.
We have filed counter, have not, they have filed a region.
They have given also.
I have not received the copy of the
Yes, I have filed the complaint.
No, have they filed the counter?
Have they filed the counter? I have given the rejoinder as well. Filed.
Have they prepared any? Is it a promotion or a direct?
No, it is a gradation list they have prepared, your lordship. They call it a gradation list of readers.
Till next date of hearing, the impugned gradation list shall not be operated to the prejudice of petitioners.
And further promotions may not be kindly given.
That shall not be operated itself. Operated. For the purpose of promotion.
Copy of the rejoinder may be directed.
I have given. I will give another.
No copy has been.
I will give. I was receipt is here.
Call this matter in the first week of October. Second week or first week is the
Item 54.
May I please a lordship? Well, this is a matter under the PCPNDT Act, my lord. Preconception and Prenatal Prevention of Sex Determination Act.
Any objections filed?
They have filed a counter.
Counter file, yes.
I'm conscious, Your Lordship rises at 4. If it's
Because
not
you're
in,
saying so many, you have to write judgments.
you can, if you can be taken up tomorrow, the top
No,
of the list.
tomorrow not. Any urgency in this?
Yes, my lord.
What is
Urgency.
that?
Because his ultrasound mission has been sailed for the last 3 months. My lord, let me apprise your lordship for the background, and your lordship will appreciate how vindictively they have been dealing with me for the last 3 years. This is the third litigation, my lord. First started in the year 2053.
Call this matter on 8th.
8th, my lord, from 5th to 10th, I would be there. My lord, can I pray?
Can we have it on 12th?
I can have it on 12th. But if I can pray anytime tomorrow, my lord.
I have difficulty now. Many cases we have posted.
I know. I'm conscious of that.
That's the
only thing is that, my lord, his only source of livelihood is his ultrasound machine. They have completely vindictively. This is a third round of litigation. First, my lord, they keep my pending for renewal, pending for more than the prescribed period. This honorable court allows me on deemed approval to run the ultrasound.
We'll take up that day.
On 12th, my lord. Then I lord, little top of the list, then my lord.
Let it be there. If it does not reach, just mention.
Appeal provision is there.
No, appeal is not in there. That's appeal is against rejection of renewal. Here they're not doing so.
It's renewed.
No, it's not renewed. I think I have to apply.
Even what benefits he will derive by going to appellate authority, all your statutory authority, we have been seeing what relief they are getting at the hands of appellate authorities, review authorities. Nobody is getting any relief.
And those are absolutely arbitrary action on part of the opposite parties.
You reserve some arguments for the next day.
I'll do.
Yeah.
I'm obliged, my lord. But the only thing is 12th.
Okay.
Item 56, obviously.
56, any short section?
One password, my lord, my seat.
So password is not possible. Only 2 minutes. Never can I pass over?
Kindly take this.
By the time I dictate, it will be over.
Tomorrow, my lord.
What is the urgency?
We have also
If you are not furnished, letter 55 is what? 56, no? This is 56. Neither ID nor answer notice returned. Service is not complete. Post office service. Next.
Item 58, it is analysis.
Yes. 58.
The 50 to 61, that block grant pension matters adjourned to after 3rd week of September.
58.
58.
Order dated 5/8. We've seen what is that 5/8 order.
It is same matter.
Yes, it is served already.
It is same matter, the block grant pension ballot.
Block grant
pension ballot, not simple.
In the 3rd week of September.
Yes, my lord. 3rd week after 3rd week of September.
Third week of
Mention 59.
59. JD not returned. So post office service. Yeah. Okay. Other what?
Pardon, my lord. Item 64. This is the academic matter, my lord.
64.
64, my lord. Only for correction of the petitioner father's name, my lord.
In 64.
In 64, my lord.
Father's name in
father's name, my lord.
In what?
In my lord, in mapping certificate, my lord.
Matriculation certificate.
My lord. Only age is extra added, my lord.
Yes, to be added.
My lord. Age is extra added. Is to be deleted.
Is to be deleted.
Deleted, my lord.
Who?
Last occasion, my lord.
Who is your?
I have already sought the copy, my lord, last occasion.
Of the copy, I am writing on
It is entrusted on other. To which advocate it is entrusted?
Yes, Shailaja.
Yes, Shailaja. appears for all OPs. OP number?
Only the OP number 3, my lord.
OP number 3. Yes.
No, sorry, OP number 3, my lord. Board of Secondary Education, my lord. 134, my lord, take notice, my lord. We have already
served, and your name is not shown.
No.
ASC for
the state opposite party, my lord.
1, 3, and 4.
My lord, except 2.
Huh?
Except 2.
Except 2. Yes.
Face admission, setting up face admission.
What is the urgency?
No, he's take admission in class.
Why that urgency? Where is the urgency?
No, urgency is he's take admission in class 2, my lord. Resident. He's the authority requires the
Call this matter on 18. Yes.
Procedural, sir. Item 62. Today copy already filed. So my post time. Copy today filed, my lord. AG copy. Sure, copy.
He's asking for time.
Time, post time.
For time, post time.
We'll give you 4 weeks.
Yes, item 63, my lord. It is a matter of admission of B.Ed course, my lord. Your lordship has kept one post vacant, but the admission is already completed and classes are started. For that reason, I pray let it be tomorrow, my lord, because your lordship is directed to give the OMR sheet and other things in sealed cover.
Lord, we have kept one sheet reserved, my lord. Only, my lord, some time may be granted to file the OMR original in OMR sheet.
By that process, it will be classes.
No, classes you will learn, na?
We have already instructed, my lord, only they only pray for some time, my lord, because we have the system generated, we have received.
You are let your client go and sit in the classroom.
Yes, my lord.
Okay. We'll give time. Which is that
Sadawala Women's College, your lordship last time kept one seat.
OP number?
He is not the OP number. And Sadawala
college is not
college. You kept one seat vacant last order, your lordship may see.
But it kept vacant is all right. But
next week, my lord.
Your lordship is directed.
When classes started?
From this week, it's classes already started.
From this week?
Yes,
no problem. We can have this matter on 9th.
Well, 9th, top of the list, may I pray, because it will be carry on.
When it is listed, you mention. Because I can't put it because computer will not accept that.
Your lordship. Intermodal may be extended.
We want to continue. Yes.
Pattern to making mention item 65 on behalf of Mr. Prabhakar Deva.
You want to file fresh one? What is that? It defect MC number 2002 matter you want to withdraw and with liberty to file again. How? Counsel for the petitioner has filed a memo dated so and so seeking leave of the court to withdraw the petition with liberty. First off, memo reads as under. Next paragraph. In view of the above, petition is disposed of as having been withdrawn with liberty as sought for. Okay.
I got this to judgment, my lord. That judgment I got.
You got that judgment? Yes, give that.
Exactly what my lord want that I do not. But I have one of our High Court that
judgment.
No.
My judgment is there.
So I could not just immediately, I could not get it. Another court referring to this judgment which has been taken note of Traffic Mercy. That's Supreme Court judgment, my lord. That is in 2024. Disposed of.
Let us see.
Item 45.
Yeah. Yes, sir.